Please.
To Mr. Mukasey. I want to make it one thing very clear. When this Supreme Court Practice and Procedure Act came into force, or became in the form of a bill and later became an act, I read clauses 1 and 2 thereof. Your lords have this act in front of you.
I think one of the petitioners has filed it. It's CMA 5104. I don't know who is 5104. It's attached with it. Ji, please read it. Argue as you please.
By the end of your lordship,
which is the petition that you?
I will be starting from 6, sir, because 6 is the one when the orders have been passed. But may I also say?
No, you started with the Practice and Procedure Act. You wanted to read it.
I'll read it. But before I do that, there is an order dated 2nd of May.
Ajay sir,
we have to forget about the past.
Because we are not, don't do this.
Okay,
so
I'll say, let's bury the past.
Don't bury it, it's past. You can't bury the past.
All right, for the time being,
we argue as if you are arguing for the first time. Thank you.
But I do say here.
I may ask a question. You have endorsed the sitting of the full court, which is fine. But I'm just wondering what will happen to Section 5 in the event if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come back. I'm very thankful to leadership, because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
It says that an appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Khalid Sahab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start with the Act at least.
I would like to answer that when I'm going through this, because this is a...
So let's start reading the Act. Do you want to read the Act or you don't want to read the Act?
I will read the Act now. I'll start with Section 1. But first of all, let me say this one. I would just state this thing, that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No, let's not do that.
Let me say.
This is public time.
When I saw this Act,
let's read it. When you saw it, we're not interested.
Well, see the Section 2 thereof.
Please read the whole Act.
I read it, sir. Whereas Article 191, I'm reading the preamble. 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Ajay Sahab, please focus.
Okay, I'm focusing myself.
We know the 1980 rules.
Background.
No, please don't. We don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If he'll ask a question, please answer that, but proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now section 2, it
Please
says,
continue, don't jump to section
Okay, all
2.
right. And whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co.
Yes, sir.
Over
This,
so
no,
we all agree that Parliament has limitations.
Yes, sir. This law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted. Read it
Okay,
on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedures Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal, or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, one of the 1980 rules, Order 11, read in this manner. Well, if you have to correlate, it may be important to do that.
पहले अगर इस एक्ट को पढ़ लें हम ताकि हम सबको पता लग जाए कि इसमें क्या है क्या नहीं.
Sir, which rule were you referring to?
If you want to continue like this, we'll go ahead. Because my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting as a full court. When they framed the 1980 rules, the entire court sat together and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office. Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm
So what
supporting.
is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your
Khwaja
proposition.
Sahab, I think you should read
if
the
this-
law first, Khwaja
if this
Sahab,
is-
and then formulate
let us-
the points.
let us first formulate-
Act पढ़ लीजिए,
पहले
उसके
act
बाद
पढ़ लें, फिर एक-एक को
it
देखें।
is only 2 pages act, it is only.
Let me follow the Chief Justice.
Khwaja Sahab,
Let me read the law and then we make my submission.
If I may make your job easier, undoubtedly, it's sometimes very difficult and disconcerting if
I know it's very difficult to get the answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take. When you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. Okay? So, please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and formulating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right, I'm just saying that your lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We will read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read Article 191 of the Constitution.
191?
What is said?
191 also.
Who makes-
In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the Federal Legislative List may originate. I will skip that. I'll go straight on to subclause 4 of Article 70. In this article and the succeeding provisions of the Constitution, Federal Legislative List means the Federal Legislative List in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis-e-Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142, subject to the Constitution, Majlis-e-Shura shall have exclusive power to make laws with respect to any matter in the Federal Legislative List. Then I take your lordship to 191, which is to the effect subject to the Constitution. Again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
These powers are under the Constitution, your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also, I'll come to that also. Because when I read 55, then it will be clearer.
Khaizab, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord. Jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Khaizab, just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with that. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution.
Supreme Court Practice and Procedure Act 2000.
That you will not legislate regarding Supreme, but you can give them, enlarge their powers, or supplement them. What will the meaning of that? That will be explained by my associates with case law.
Mr. Khwaja Sahab, the two crucial expressions are jurisdiction and powers. And the law that you are challenging does not concern both of these expressions.
Yes, sir. Point noted. Jurisdiction and power. Jurisdiction and power. Well, I'll answer that.
आप नोट कर लें ये सवाल.
सवाल आपका मैंने सुन लिया जी. Please note this down that we have to have jurisdiction and powers both. We'll explain both. We'll explain both. This is what the Constitution says. Now, this is regarding the benches, Section 2. In one word, I would say this, that this power of 191 gives the power to the Supreme Court itself to regulate its procedure, as has been done in the past, as has been held in a number of cases which we bring before your lordship. Those cases are well known.
Now I just ask a question. You can note it. Are you suggesting that that even the rules of 1980 are ultra vires the Constitution? Please let me finish. Because the power vests in the Supreme Court as all the judges of the Supreme Court. That could be one reading of your argument. So you are saying that Section 2 is the ultra vires of the Constitution, which gave power to 3 persons. Order 11 of the rules is ultra vires because it gave power to 1 person. Is that your proposition?
No, madam. My proposition is very straightforward. As far as the 1980 rules were concerned, they were made by a full court, which was at that time. The entire historical perspective has been given. My proposition is slightly different. These were under 191. It is the function of the Supreme Court itself to regulate it.
Okay.
See, 184.3 is not the only part.
Khwaja Sahab, you can make your you can later answer my question. So what you are saying is that the expression subject to the Constitution and law, this becomes redundant? That is the question. That is what you are interpreting it.
I'll answer that. We'll
And
answer,
the
we'll
law
answer that.
is enacted by the Parliament.
We noted, we'll answer this thing. But my basic question, why I came before your Lordship, is that the functions which are there with the Supreme Court, there should not have been there with the Parliament. Because that institution that has its own, today they say that how you are going to have the benches, tomorrow they will say that such and such bench will have this case, such and such bench will have that case.
Please,
You can say that also.
please, let's not go into
Well,
what they may or may not do.
Why I'm saying is this, that if I give them
no,
unbridled power,
no.
then anything can happen.
Raja Saab, it pertains to your attack on a particular piece of legislation.
But I will
Please
say this thing.
no. What Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this thing then, Maharaj, that this clause 2 is beyond the powers of the Parliament. Three, and when I'm arguing, Maharaj, my associate will explain that 184.3 is not the only thing which is regulated by the Supreme Court rules. If your Lordship would have the 1980 Supreme Court rules in front of you, there are the different types of jurisdiction which are available to you.
Shall we finish with the act quickly?
Okay, I'll finish with the act, Maharaj. Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Section 1 of Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is...
Raja Saab, sir, on your right side, but not
Ji.
as much right as previously. Yeah,
Yes, Maharaj.
over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power, or is this a judicial power, or is this an administrative / statutory power? Because 183 is ultimately a judicial power, because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power, but an administrative power. So can Parliament whittle down? This is a question, please note.
Yes, it's
Whittle
noted, sir,
down
and
the
in fact, that is
whittle down power-
that will be exactly my
Raja Saab,
proposition.
please, hear his lordship.
सवाल तो सुन ले. Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels? 3 judges, not the whole of the Supreme Court, but 3 judges. Senior most respectable judges, but in the end, just 3 judges. Block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an
And I will go even further than that,
And also a supplementary question connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. if this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the parliament wanted to address.
I would,
If I may add, there is a judgment of this court and the judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would record reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
in fact,
Ajay sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
Yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this? So this is not a question of composition of benches. That is power universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? Question is maybe noted.
and
You don't have to answer.
No, I'm not
Please
answering.
carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your
Your
solutions.
Honor has
Just note the question.
this thing. I will add one thing to it. It also deprives of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I'm being condemned. I'm not being heard.
Who is
The
that?
party is not being
Please,
heard.
who is, when you're using the word I, who is the I here?
Litigant. The litigant. Because
एक second, sir. Tahammul. The litigant, that leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner and I'm saying this thing that we brought this petition
Take up a point
in
noted.
the interest.
You got the answer, got the answer.
In
Now
the-
please proceed. I've got the answer.
Because in the interest that that the law should take its course. The constitution must be upheld. And I am also saying that I'm sure with such preliminary sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please.
I will not,
We are not going to
I will
platitudes.
not make a political speech.
Khwaja Sahab,
I'll refrain
Khwaja
from
Sahab,
that.
Khwaja Sahab,
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your
I think
proposition.
your lordship is possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Why
it does not?
Instead of
Khwaja Sahab,
Section 3 is a totally different thing. It takes away the powers of this honorable court. Why
it does not?
instead of
Khwaja Sahab,
Is
Khwaja
it
Sahab,
your
let us
argument?
clarify.
Is it your
It
argument
takes
that
away the
section 3 affects the judicial powers of this court?
yes, sir.
Curtails judicial powers of this court because this court means the Chief Justice and all
the
judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's my point.
I've been trying.
2 and 3 have to be read independently and separate.
Now, please,
And that too an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing. Keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
In fact, to be very, very
Excuse
honest,
me.
I welcome this interruption.
Can I ask
For
you a
a simple
question?
reason. Yeah,
Can I ask,
far right.
please? What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down. As if this law goes through, the powers will be whittled down, but we'll explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000.
ऐसा फिर आप आंसर करने
All right,
बैठ गए।
I will continue. Let me
आप नोट
continue.
कर लें या बाद में
Okay,
कर लें।
let me continue.
Mr. Khwaja, I will add.
Then is a
Mr. Khwaja.
Yes, sir.
Right side.
Right side.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I
This
think
is the moot question.
the answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court
Khwaja
is
Sahab,
Chief
Khwaja
Justice
Sahab,
and so
if
many
you-
other judges.
Khwaja will be sitting here till 12 o'clock.
I know that, sir. Let's
So आप जरा
let's go.
अपना आर्गुमेंट करें।
Or,
अभी जो हम सेक्शन
let's
3 पे पहुंचे।
let me, on section 3, I will only say this thing, that this certainly is, the parliament has taken away the power, not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition, I've not even heard, and 3 judges or 2 judges, they will decide on an administrative side and I'll be out. So the question of 184(3) will become totally redundant. This is my point.
जी, आगे बढ़ते हैं।
Therefore, to that
Let's
extent,
put-
section 3 is. Then next is 4, interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object for say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or make, why not 7,
Yes, sir,
why not
please,
6?
please,
I
No, you're
object
arguing-
to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just say, is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges.
ठीक, well noted.
Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, it's not less than
आगे
5.
बढ़ें, आगे
Ajay
बढ़ते
Saab,
हैं।
as I
Then there's
understand,
a question of appeal, and which is a very relevant point.
Ajay Saab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have
But if a
I have
committee-
noted this thing.
Yes.
Your Lordship did not, sir, I would not be able to explain my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the parliament. About how the benches are to be.
आगे बढ़ते हैं।
I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your
No,
suggestion.
sir, I'm saying this thing that another 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your function. It is not the function of the parliament.
ठीक है, now let's proceed. We'll ask.
I'll argue on that.
लेकिन
That
अगर आप-
is the point which needs consideration. 5 is appeal. Yes, Mani, sir.
On section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches. The question is this, that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this, if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
मैं बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा को फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए, सवाल तो सुन लें
जी जी
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत, ये आपकी बहस है ना सारी।
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर, ऐसे नहीं है।
सुप्रीम कोर्ट
नहीं सर, ऐसे नहीं है।
चलिए बस नोट कर लें, फिर आप बात करें।
मैं नोट कर लिया कि जब सुप्रीम कोर्ट
कोर्ट जब कर
आप
लिया,
जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो
नहीं
जाएगा।
नहीं, मैं I'm quite I have a very
नहीं, आगे बढ़ते हैं,
I have worked with all of you sir,
नहीं, आगे बढ़िए।
I have no problem.
हजूर आगे बढ़िए, आगे बढ़िए।
If I may, Khwaja sir.
problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes,
Sir,
ma'am.
if I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked. Independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question surely, this is the question to you. Surely the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary legislation.
आप नोट कर लें, जवाब ना दें।
Not through ordinary legislation.
If I will really request my colleagues that they are making, including myself, are making your life impossible.
I'm
No, please, no, you are very fine.
I'm
No.
learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way. आगे बढ़ते हैं.
Let me say this.
Mr. Khwaja,
Khaja Sahab, section 5 से आगे पढ़ लीजिए.
another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहां तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 हियर आर्टिकल 183 तो ये क्या दोनों में?
Sir, it is
गलत है तो फिर वो भी गलत है.
It is not. We'll answer this thing. What Parliament can do and what Parliament can do many things. My Lord has said so. But there is a procedure provided. Will answer that.
भाई साहब, अभी जो आपकी जरूरत नहीं है, आप
I will not answer.
पहले एक्ट को खत्म कर
Section
लीजिए.
5 से आप आगे बढ़ लीजिए. Khaja Sahab,
Khwaja sir,
you have collected 100 questions.
Just here. The Law Reforms Ordinance of
How you will
1972.
answer.
This is the question to you. Regulated right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clause is there only in respect of the Supreme Court. Law Reforms Ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clause was only in relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example with which relates only to the high courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clock.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person of this act, provided that the appeal under this section shall be filed within 30 days of the commencement of this act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're saying I'm not going to do it.
My lord,
You have challenged the
my
law,
lord,
you have
my
to
lord,
do, you have to challenge
the
it.
appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
As far as section 5 is concerned, the
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in clause 2, whereby my 184.3 application will be disposed of?
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us unconstitutional about it.
Then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different from ultra vires a constitution.
It ought to have been given.
But then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे.
You have done this.
नहीं, ये नहीं, आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
To make it more simple, you don't want your client to have a right of appeal.
No, sir,
You first say it's unconstitutional, it's constitutional. You're not saying anything. You just. यहाँ कोई discussion होता है. Sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the.
Please answer the question. Is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है.
Unconstitutional.
My personal opinion is this, that this section 5 goes beyond the powers which were there with the parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under section 184.3.
Okay.
And this appeal to this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions. Please let me finish. Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the appeal be given, but the manner in which it has been given. is wrong.
Please, take it.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the constitution.
It is unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184.3 is a substantive provision of the Constitution. If a
You
right
are
of
happy
appeal-
with no appeal.
Well, Lord, if a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken, move ahead.
I just have a question to you with regard to section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you has two parts. So the first part is this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of the legislative competence conferred by Article 191 in relation to practice and procedure, confer a right of appeal? Because if I may, and this is the point, I apologize. My question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You
This
don't
is
have to, you don't have to give an answer.
This
Just
could have been, if the right of appeal had to be given, it should have been given through an amendment.
Note it down.
Yes, next is right to appoint.
आप चाहें तो आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्गुमेंट चलाते रहें, जी आगे बढ़ते हैं। सोच 6 को पढ़िए, 6 को।
Right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice. I personally don't object.
पर्सनली की बात कोई नहीं है।
I'm not objecting to this because I feel that
Okay, it's okay. Chaliye, let's get on with it. Section 6 is okay.
application for fixation of urgent matters, where application pleading urgency or seeking interment filed in a cause, appeal or matter shall be fixed for it. My objection of this is again that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires the Constitution?
It's ultra vires.
Thank you.
I just have a question on you on this, on section 7. Now, section 7 really relates to what has been stated as the nitty-gritty of procedural law. I mean, this is really going, say, in a civil court, into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question, therefore, is this. The legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the?
This was my very first point, which I said,
Sir,
that the functions of the
is
Supreme
it,
Court have been virtually been taken over.
is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra vires.
इसमें ख्वाजा साहब Khwaja Saab,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at aspect of independence of judiciary, that is, freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of
Just note kar le.
the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
Sir, we will certainly answer your lordship.
Yeah, but please, one question also.
Since we have just
Raja
one
Saab.
section, can we just finish reading it?
Raja Saab, if I may have a supplemental on
Yes,
what
sir.
my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
working
of
of
the
the body.
judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers? Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That you say, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean, where would
Saab,
that
ek
bring
second.
us?
Saab, ek,
With due respect,
That is a question,
my lord.
Khwaja Saab, ये एक बात सुनिएगा, is a question.
आप इसको खत्म तो कर लेना सेक्शन को आप सॉरी टू से
आर्टिकल 8 खत्म कर लो।
आप पढ़ ही नहीं रहे हैं।
मैं पढ़ लेगा, अभी पढ़ लेता हूँ सर। ये सवाल बड़े पर्टिनेंट
आप हर चीज आप नोट कर लेना।
नोट कर भी लिया मैंने सर, कर लिया। मैं बता, मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था, आपने शायद इसका और जो ये आप कह रहे हैं, तो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है, उसमें किसी और का दखल नहीं होना चाहिए। ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा।
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the counsel of his own choice. No, when the law is totally ultra virus, then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, what I'm saying
Yes,
is,
according to your own
that
arguments.
the question is that you cannot provide a right of appeal,
But you can
under
provide the right of review.
under 184(3). If 184(3) right of appeal is given in accordance
आप
with
मेरे ख्याल
with the
में
constitution, then as far
ख्वाजा साहब फिर आप अपने लिए
Okay,
आप जरा सुन तो लीजिए ना। आप ये सवाल जो है जरा सुन, आप सुन तो लीजिए ना। ये जो सवाल है इनको इतने इजीली ब्रश असाइड ना कीजिए, जरा सुनिए प्लीज। आप गौर और फिक्र से, हम नहीं चाहते हैं कि आप फिलबदी कोई जवाब दे दें जो फिर आपके लिए मुश्किल हो। हम इसीलिए आपको कह रहे हैं हर सवाल नोट कर लीजिए, आराम से जवाब दे दीजिए। आप खुद अपने लिए मुश्किलात खड़ी कर रहे हैं, हर सवाल के जवाब देने लगते हैं। हम तो सिर्फ आपसे सवाल पूछे, नोट कर लीजिएगा आगे चल करके, ठीक है। हम देखें, हम एक दूसरे से तरफ बहस करने नहीं बैठे हैं, हम आपके सुनने का, आपने चैलेंज किया है एक कानून को कि ये गैर आईनी है। ये बहुत फर्क होता है कि एक कहने के लिए कि मुझे ये कानून पसंद नहीं है। जरा आप प्लीज ना खामोश रहिए 2 मिनट, हम भी आपको सुन लेते हैं खामोशी से, आप भी थोड़ा सा तहम्मुल का इजहार कर लें। तो ये बहुत से कानून है, शायद मुझे भी नहीं ज़ाती तौर पे पसंद हो, मगर मैंने हल्फ उठाया है कि मैं आइन और कानून पे अमल करूंगा, ताकि अनलेस कि मैं उसको स्ट्राइक डाउन कर लूं कानून को, वो एक अलग बात है कि ये अल्ट्रा वायरीज द कॉन्स्टिट्यूशन है। तो आपने कहा माय पर्सनल ओपिनियन डजंट मैटर, तो आपकी भी पर्सनल ओपिनियन की कोई हैसियत नहीं है। आपको आईनी जवाब हर देना है कि ये इस शिक, आपने एक बहस में एक आर्टिकल आइन का आपने रेफर नहीं किया कि ये किस आर्टिकल के तसादुम में है। दूसरी बात आपने जो बिल्कुल नजरअंदाज कर रखी है, ये हमने स्यूमोटो केस नहीं लिया। अगर हमारे हकूक पे इतना जबरदस्त वार पार्लियामेंट ने किया होता तो हमने बहुत सारे केसेस में हमने खुद भी उठा लिए केसेस को। ये तो आप हमारे तरह से वो डिफेंडर तौर पे रूनुमा हुए हैं और कहा ये जंग मेरी है, ठीक है। ये सिर्फ प्रोसीजर मैटर है, इसमें किसी की राइट गायब नहीं हो रही, किसी की राइट, एक राइट कन्फर हो रही है, किसी की राइट छीनी नहीं जा रही है। तो बराए करम आर्टिकल 184(3) के दायरे में रहकर आपने, जिसका आपने एक लफ्ज नहीं जिक्र किया है, वो कहता है एनी मैटर ऑफ पब्लिक इंपॉर्टेंस। चलें जी, पब्लिक इंपॉर्टेंस तो एक वो है डिबेटेबल क्वेश्चन, हम ये कहूँगा, आप कहेंगे वो है, मगर फॉर द इन्फोर्समेंट ऑफ फंडामेंटल राइट्स, ठीक है, ये इसके प्रीएम्बल में उन्होंने फंडामेंटल राइट्स का तस्करा कर दिया है, जिसको आपने बस नजरअंदाज कर दिया। ठीक है, ये बहुत अच्छी बात है कि आप मेरे हकूक के लिए जंग लड़ रहे हैं, मगर ये मेरे हकूक और आपके हकूक की नहीं बात है, ये आइन की बात है और लोगों के हकूक की बात है। ये आर्टिकल 10(a) का हवाले देता है, आर्टिकल 25 का देता है। तो आप खड़े हो राय, आप कॉलम लिखिए अखबार में, हमें सिर्फ और सिर्फ आईनी बहस कीजिए कि ये 184(3) का जो हम जो पावर आज इस्तेमाल कर रहे हैं, वो 104, ये हम अपेलेट पावर नहीं इस्तेमाल कर रहे हैं, ना कोई हाई कोर्ट ने कोई फैसला किया है जो हम बैठे हुए हैं एज ऑफ राइट अपील सुन रहे हैं, पिटीशन फॉर लीव टू अपील सुन रहे हैं। हम ओरिजिनल जुरिसडिक्शन में बैठ गए, उसकी बहुत महदूद चीजें, मुझे बहुत सी चीजें कानून में शायद ना पसंद हो, मैं ये नहीं कह सकता हूँ कि जी इसको ऐसा नहीं करना चाहिए था। तो आप बराए करम, आपने एक सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट से तो आपने कुछ बहस ही नहीं की अभी। जरा आप प्लीज, और हर बात को आप नोट कीजिए। अगर आप
मैं नोट
तो बस आप हर चीज को जवाब देने लगते हैं बगैर सोचिए। हर बात की बहुत अहमियत होती है। मेरे कुलीग के जो सवाल हैं वो बड़े अच्छे सवाल हैं, जरा गौर और फिक्र चाहते हैं और फिर जवाब देते हैं। अगर आप जल्दी से करेंगे फिर आपको दोबारा मौका नहीं देंगे, फिर कहेंगे अब मुझे अच्छा जवाब आ गया। तब आप प्लीज 184(3) के तकाजे भी पूरे कर लें।
आपके बिल्कुल 184(3) के तकाजे
मेरा एक सवाल भी नोट कीजिए, केपी ऑन द बॉर्डर प्लीज। आप क्या सोचते हैं, दिस एक्ट हैज बीन पास्ड इन द पब्लिक इंटरेस्ट? क्योंकि सेक्शन 5 सबसेक्शन 2 says on the contrary. It appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, क्योंकि commencement उनकी कर दी है और उसमें कोई limitation भी नहीं है, तो ये public interest में पास हुए या personal interest में हुए?
Yes, your point is noted, sir. I will not answer now. I'll answer it later.
Mr. Khwaja, another question.
Sure.
Please एक और note कर लें. We have two provisions in the Constitution. One is Article 191, which relates to Supreme Court, and the other is 202 of the Constitution, which relates to High Court. Same अल्फाज है, वहाँ पे Supreme Court, यहाँ पे High Court. Subject to the Constitution and law. Law तो बनाती है Parliament. तो आपके आर्गुमेंट से हम ये समझें कि पार्लियामेंट को आप लॉ मेकिंग में महदूद करना चाहते हैं कि आप ये तो कर सकते हैं, ये नहीं कर सकते, ये रूल्स में सुप्रीम कोर्ट खुद करेगी, खुद करेगी।
सर मैं इसका आंसर दूंगा, बिल्कुल दूंगा कि जब सब्जेक्ट कॉन्स्टिट्यूशन आ जाएगा और जो लॉ आएगा वो आपको कॉन्स्टिट्यूशन के साथ देखना पड़ेगा।
बात ये भी कि क्या लॉ के तहत क्या कर सकते हैं पार्लियामेंट, क्या नहीं कर सकते?
क्या नहीं कर सकते, ये इसका जवाब देंगे जी आपको। इसीलिए तो
another question, where a rule has been framed under constitutional power granted to this court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additional through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
हुजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना।
Number 7 is application for fixation of urgent matters.
ये तो हो गया।
Application pleading urgency or seeking interim relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ। आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ, मेरी मर्जी। सिर्फ जवाब दे दीजिए, मेरी मर्जी। मैं 10 साल उस केस को नहीं लगाऊं, मेरी मर्जी।
मैंने इसमें कुछ नहीं कहा,
मैं आपसे सवाल पूछ रहा हूँ जी। इन्होंने मेरी मर्जी ले ली, शायद मैं खुश नहीं हूँ इस बात से, मेरी मर्जी में ना लगाऊं केस। एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका, भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें। तो मैं कहूँगा मेरी मर्जी। मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा। इस पे सवाल का जवाब दीजिए, मैं नहीं लगाता हूँ। आपका ये केस फाइल किया, ठीक है, मैं नहीं लगाता इसको। आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं, आपके हाथ पैर कटे हुए हैं। इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की, मैं 2 बातों का इजाफा भी करना चाहता हूँ, और वो है, और वो आइन से पहले भी हमारे पास था, वो हमें ऊपर वाले को हिसाब देना है, ठीक है? अकाउंटेबिलिटी एंड ट्रांसपेरेंसी। आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को, मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीजों को छोड़ करके, ठीक है? इस कानून को उड़ा दे, मैं ताकतवर बन जाता हूँ, ये भी है। मैं अकाउंटेबल हूँ, ये भी एक सवाल है। आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है, ठीक है? और हम सब everyone exercise powers as a sacred trust। आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे। तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाजा बंद कर रहा हूँ तो वो तो मैं बिल्कुल, मुझे इस्तेमाल नहीं करना चाहिए। आप ये पिटिशन लाते, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाते ही नहीं, तो हम ये बेकेस ही नहीं सुनते कभी। 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे, आप खुश थे उस बात से। तो बराए करम आप ये जो बार बार बात कहते हैं ना, मेरी मर्जी, मेरी नहीं है जब मैं चीफ जस्टिस हूँ, तो बराए करम हम वकीलों को बहुत ही कदर करते हैं, मगर मेरा का लफ्ज ना इस्तेमाल कीजिए। अंग्रेजी में कहते हैं मी, माई सेल्फ एंड आई आर द 3 मोस्ट यूजलेस वर्ड्स इन द इंग्लिश लैंग्वेज। इसका मैं उर्दू में तर्जुमा नहीं कर सकता हूँ, बेहतर कर सकेंगे। बराए करम आइन का हवाले दे दीजिए किसी चीज के मुतालिक कि ये आइन के तसादुम है, वो आइन से तसादुम रखता है, ये शिक के आइन से तसादुम। अभी तक मैंने आपसे वो एक लफ्ज नहीं सुना है इस पर। शुक्रिया।
मैंने तो 3-4 जगह कह दिया है कि जहाँ पे 184(3) में आप अपील का राइट दे रहे हैं थ्रू दिस ऑर्डिनरी लॉ, ये हो नहीं सकता, बिकॉज दिस कैन ओनली बी डन बाय अ कॉन्स्टिट्यूशनल अमेंडमेंट।
लफ्ज लिखा है अग्रीव्ड पर्सन, ठीक है? अब देखिए, अब एक मफहूम तो ये निकलता है 184(3) का कि आप ऐसे मामलों में ना उलझाएं अपने आप को जो इनफरादी नौयत के हों।
अग्रीड सर,
जरा अग्रीड, आपसे अग्री करें या ना करें, मैं जरा बात कर लूं। इनफरादी नौयत की, अगर हम इनफरादी नौयत के केसेस फैसला करने लगे तो वो बेचारा कहाँ जाएगा? मैं आपको मिसाल दे देता हूँ। रेकॉर्डिंग का केस चला, दोनों केस फैसला हो गए तो मैं इस पे बात कर सकता हूँ। रेकॉर्डिंग का आ गया, ठीक है, सुप्रीम कोर्ट ने 184(3) में एग्रीमेंट उड़ा दिया। मुल्क को, सुप्रीम कोर्ट को नहीं, मुल्क को $6.5 बिलियन की डज लगी। हमने कौन सा जुरिसडिक्शन इस्तेमाल किया? हमने एडवाइजरी जुरिसडिक्शन इस्तेमाल किया। अगर हमारे पास ये जुरिसडिक्शन होता, मैं नहीं कह रहा हूँ फैसले अच्छे थे बुरे थे, मैं सिर्फ उस पर तबसरा कर रहा हूँ, ठीक है। अगर हमारे पास जुरिसडिक्शन होता, हम वो जुरिसडिक्शन इस्तेमाल कर देते। अब हमने एडवाइजरी जुरिसडिक्शन से मामलों को ठीक रखने की कोशिश की, ठीक है। आप कहते हैं नहीं, मुल्क को $6.5 बिलियन की डज लग जाए तो लग जाए, इंडिपेंडेंस आपकी चीफ जस्टिस की साख पे कमी ना आए। जी मुझे ऐसे पावर्स अपने लिए तो नहीं चाहिए, मैं अब वजाहत कर दूं। अगर आप मुझे देना चाहते हैं मैं फिर भी नहीं लेना पसंद फरमाऊंगा। आप प्लीज आइन के तकाजे पूरे करें।
मैं ये मेरा मकसद ही नहीं है। आप anyway, मैं ये आंसर कर दूंगा। ये बिल्कुल 184(3) के जो कंडीशंस हैं वो भी मैं आपके सामने पूरी कर दूंगा, और वो दो कंडीशंस हैं पब्लिक इंपॉर्टेंस एंड फंडामेंटल राइट्स। फंडामेंटल राइट्स में जी राइटली साइड से
अगर we can go back,
independence of
Raja
judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter? Then that full right of appeal is no longer there. It's redundant. It doesn't exist. So what is you have read the law now. इसके ऊपर आप बता दें कि
और इसमें इसी के साथ एक सवाल, ख्वाहिश साहब इधर हूँ जी, जरा 5 मिनट लगते हैं आपको मुझे देखते।
नहीं सर, आप उसमें
मैं आपसे सिर्फ इसी सवाल चलते हैं कि इस 4 में लिखा है कि 5 या 5 से ज्यादा जजेस का बेंच बना सकते हैं ना, तो फुल कोर्ट भी बना सकते हैं ना 4 में। तो फिर 4 को 5 को इकट्ठा पड़े तो अगर फुल कोर्ट बन गया तो फिर उस केस में अपील नहीं होगी। बस आप इसका भी जवाब दीजिए।
बल्कि
तो इसमें एड ऑन क्वेश्चन होगा कि डज दैट नॉट मीन कि हम फिर वंस अगेन खुद ही डिसाइड कर लेंगे, जहां हम नहीं चाहेंगे कि अपील कोई हो किसी केस का तो फुल बेंच बिठा देंगे? डज दैट अगेन नॉट अमाउंट टू अ पावर being exercised by the court itself? So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
एक क्वेश्चन और भी इसी में ऐड कर लेते हैं इस तरफ। अजय साहब, to your right. हम ये भी देखेंगे through this petition there is an order of this court, the act has been suspended, whether in presence of that order full court can be constituted or not, ये भी जरा court can be constituted or not.
आप जवाब देना पसंद फरमाएंगे या हम shall we proceed to the next council? फिर आप सोच करके आप जवाब दे दीजिए, ठीक है?
मैंने तो पब्लिशिंग कर दी,
ठीक है, आप आइए। कौन आर्ग्यू करेगा नेक्स्ट? अच्छा, आप अपना किस पिटीशन में अगर बता दें।
तीनों में ख्वाहिश साहब के साथ
जी,
तीनों में ख्वाहिश साहब के साथ।
to right of two counsel is not allowed unless you are separate petitioners.
7 में and 6 हम बैठे हैं, एक में आप 7 में मेरी हाजिरी हो गई।
जी चलिए बताइए।
Well, the proposition requires to be refocused. There is the fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question. With utmost respect, the primary question is whether 184(3) can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction. You have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
Well, Lord, there are number of judgments.
I'm not interested in judgments. I'm talking about arguments.
I am making submission about it. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court constitutes.
मैं फिर आपको बात समझाया नहीं सका. For instance, let's take income tax ordinance. ठीक है, ठीक है, उसको आप बिल्कुल स्ट्राइक डाउन कर सकते हैं और उसको चैलेंज भी कर सकते हैं आर्टिकल 199 में हाई कोर्ट के पास, ठीक है, हम क्यों jurisdiction exercise करें 184(3) की? ये शायद आपके हिसाब से ये कानून दुनिया का बदतरीन कानून हो सकता है, ठीक, मगर बुनियादी सवाल 184 का दरवाजा जब आप खोलेंगे तो उसमें दो चीजें हैं, मैटर ऑफ पब्लिक इंपॉर्टेंस, सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट्स। बता दीजिए कि चलिए पहले वालों को जरा ग्रे एरिया है, दूसरे वाले में तो बता सकते हैं ना फंडामेंटल राइट। पार्लियामेंट अच्छा कानून बनाए, बुरा कानून बनाए, ये हम पार्लियामेंट्री डिबेट इधर नहीं करेंगे। आप 184(3) में हो सकता है कल को हाई कोर्ट में आप ये पिटिशन लगाते, वो अलाउ कर देते आपकी पिटिशन, फिर आप हमारे पास एपेलेट जुरिसडिक्शन में आते, हमारे पास बहुत खुले होते। अब आपने बहुत नैरो इंतखाब किया है, 184(3) का इंतखाब किया है।
My lord, there are number of judgments of the Supreme Court.
जजमेंट्स हावी नहीं होते हैं आइन पे। अच्छा, 189 पढ़ लें जरा, ये आप लोगों के जरा गलत फहमी क्यों है? 189, एक सेकंड, 189 पढ़ लेते हैं साथ में, जरा पढ़िए 189। जी,
Any decision of the Supreme Court shall, to the extent that it decides the question of law or is based upon or enunciates a principal law, be binding on all other courts in Pakistan.
लफ्ज है all other courts,
Yes.
not the Supreme Court.
Yes.
जवाब दीजिए जैसे भी आप करना चाहें।
Please, Lordship.
If I may ask
Ji,
you,
sir.
Mr. Siddiqui, if I may ask you a question.
Please,
It
Lordship.
seems to me that Article 189 deals with what is called vertical stare decisis. But there is also within the Supreme Court and in each High Court what is called horizontal stare decisis, the law of precedent. That is a judge-made law, that is case law. That is not provided in the Constitution. And surely the rules, are there not rules that regulate horizontal stare decisis? For example, the full court gives a judgment. If there were no horizontal stare decisis, a two-member bench of the Supreme Court would say, well, Article 189 doesn't apply, so we are not bound by the judgment of the full court. Would that be correct? Would that be a correct understanding?
That
of
would be a
constitutional law?
fallacy, it will not be correct.
So if a three-member bench, a five-member bench gives a judgment, can a three-member bench say, or even a five-member bench say, sorry, we are not bound because Article 189 doesn't apply to us? Surely horizontal stare decisis does apply. It's a well-settled. What would you say to that?
But I would make a humble submission that the judgments of the superior courts, particularly of the Supreme Court, are a binding precedent on the subsequent courts constituted as a benches or a full court. And unless your lordship, in your lordship's wisdom, decide to overrule them, they have a binding value. And it goes to the very system of certainty within the judicial system. And to say that your lordship are not bound by the previous judgment would, with respect.
मेरे ख्याल में आप मेरा सवाल सर समझिए नहीं सही।
मैं आपको आ रही हूँ सर, मैं उधर आ रहा हूँ।
नहीं, मेरा सवाल दोबारा दोहरा देता हूँ, शायद आप समझ नहीं पाए। यकीनन सर 5 मेंबर बेंच का जजमेंट 3 मेंबर बेंच पे बाइंडिंग है, यकीनन। अब हम आर्टिकल 189 की बुनियादी बात कर रहे हैं, अदर कोर्ट्स। अगर ये बात है तो ये अब फुल कोर्ट, इससे बड़ी तो फुल कोर्ट नहीं हो सकती है ना। हमारे ऊपर कोई प्रेसिडेंट लागू नहीं होगा, आप समझ रहे हैं। अगर यही इशू किसी लार्जर बेंच ने फैसला कर लिया होता वो हम पे होगा, मगर एज अ रूल अदरवाइज जजेस डिसेंड भी नहीं कर सकेंगे ना, वो तो बाइंडिंग है, डिसेंड भी नहीं कर सकते हैं। तो अब आप जरा वजाहत में ये कर रहा हूँ, ये नहीं है कि 4 मेंबर बेंच डिसरिगार्ड, 2 मेंबर बेंच डिसरिगार्ड कर देगा 5 मेंबर बेंच के फैसलों को। बिल्कुल ये मेरी, आप इसका मतलब वो बात समझ नहीं पाए अदर कोर्ट्स। मगर अभी तो वो मफरूजों में हम नहीं जाना चाहते हैं, ये जो मौका है इस पे पूरा कोर्ट बैठा है, तो ये कोई प्रेसिडेंट जब आप साइड करने निकलेंगे तो वो प्रिंसिपल नहीं अप्लाई करेगा जब तक आप आर्टिकल 184(3) का दरवाजा नहीं खोल पाए।
ये इम्तियाज साहब, इसको मैं जरा सिंप्लीफाई कर दूं एज आई अंडरस्टूड।
सर,
ये पूरा लॉ पढ़ लिया गया है, इसमें सिर्फ 2 चीजें हैं। एक, पहले चीफ जस्टिस के पास कुली इख्तियार था कि डिस्क्रिशनरी चॉइसेस करे, ठीक है ना, उसको पार्लियामेंट ने डाइल्यूट कर दिया, रेगुलेट कर दिया। दैट्स ऑल दैट द पार्लियामेंट हैज डन, कि उन्होंने 3 जजेस को इकट्ठा कर दिया, कोई बाहर का कोई भी नहीं आया। इट्स स्टिल द चीफ जस्टिस एंड द 2 सीनियर मोस्ट जजेस। इसमें तो किसी का भी फंडामेंटल राइट अफेक्ट नहीं हो रहा, बल्कि जो इंटरनल या इंस्टीट्यूशनल इंडिपेंडेंस है वो मजबूत हो रही है। सेकेंडली, एक राइट ऑफ अपील उसको प्रोवाइड किया जा रहा है जिसके पास पहले कोई राइट नहीं था। नाउ इस दो चीजों के अलावा इस पूरे कानून में कुछ नहीं है, तो कौन सा फंडामेंटल राइट्स आप पिटिशनर का वायलेट हुआ है जिस पे आप 184(3) में आए? ये तो अगर
Your lordships have held.
समझे, अगर पार्लियामेंट ने चीफ जस्टिस की अथॉरिटेरियनिज्म को खत्म किया है, ये तो आपको सराहना चाहिए। ये तो आपके बल्कि इंडिपेंडेंस ऑफ जुडिशरी को सिक्योर करेगा। हाउ डज दिस
Respond to this. May I respond?
और सिद्दीकी साहब इसी में मैं ऐड कर दूं, सवाल ये है कि अगर आपके मुताबिक चीफ जस्टिस की अनलिमिटेड पावर्स ही इंडिपेंडेंस ऑफ जुडिशरी है, ये भी बताइएगा, क्योंकि अगर जिस तरह माय लर्नेड कॉलीग इज जस्ट मेंशन्ड कि अगर वो विटल डाउन कर रहे हैं पावर चीफ जस्टिस की, एक की जगह 3 लोग 4 लोग मुशावरत के साथ चलेंगे, तो एकदम इसलिए कि चीफ जस्टिस की पावर कम हो रही है, इंडिपेंडेंस जुडिशरी एट स्टेक हो गई है। ये नहीं देख रहे कि इंडिपेंडेंस जुडिशरी तो बढ़ गई है, कि एक कंसेंसस से आगे चलने का इंतजाम हो गया है कि आप लोग सोचें कि आगे कैसे चलना है, कोलिजियल तरीके से चलना है। सारी दुनिया में बहरहाल ये हो रहा है, कहीं दुनिया में चीफ जस्टिस नहीं मास्टर ऑफ द रोस्टर है, क्योंकि अब सब जगह कहीं जाए तो बैलेट होता है साल के शुरू में, कहीं सारी फुल कोर्ट बैठता है तो फिर चलता है, कोई चीफ जस्टिस के बाद मुंजमद नहीं है ये पावर्स चलाने की। तो ये हो रहा है, तो इंडिपेंडेंस तो इससे बढ़ रही है जुडिशरी की। एक चीज तो इस चीज को जरा देखिए कि इंडिपेंडेंस बिल्कुल कनेक्ट मत कीजिए चीफ जस्टिस की ओमनीपोटेंट पावर्स के साथ, कि जैसी चीफ जस्टिस की पावर को हम छेड़ते हैं इंडिपेंडेंस ऑफ जुडिशरी खतरे में पड़ जाती है। ऐसा कोई सिलसिला नहीं है, इसका भी जवाब जरा दीजिए।
Mr. Siddiqui, the fundamental question here is, who can do this? Who can do this? That's what I'm saying. I mean, is it a function of the granted by the Constitution? Is it the function of this, the Supreme
It is a
Court?
function,
Or is it the function of the Parliament? And if the Parliament exercises the function of the Supreme Court, then it is an intrusion in the independence of the judiciary, as I have understood, is your argument.
I am saying,
सिद्दीकी साहब एक इसमें जरा मैं ऐड कर, 191 आप पढ़ते हैं ना, तो 191 में लिखा है सब्जेक्ट टू लॉ एंड द कॉन्स्टिट्यूशन प्रोसीजर बना सकते हैं। तो 191 तो ये एनविजिज करता है कि कानून हो सकता है जो प्रैक्टिस एंड प्रोसीजर को रेगुलेट करे।
पार्लियामेंट का तो नहीं हो सकता।
सुन लीजिए, नहीं और कहाँ से कानून लाते हैं आप? हम पार्लियामेंट से लाते हैं पाकिस्तान में कानून।
जज मेड लॉ।
नहीं, लॉ, कॉन्स्टिट्यूशन एंड द लॉ,
कन्वेंशन।
सुन लीजिए, टू लॉ एंड द कॉन्स्टिट्यूशन, कहीं से लॉ एक एग्जिस्ट कर सकता है, आईन मानता है कि ऐसा कानून हो सकता है जो कोर्ट की प्रोसीजर को रेगुलेट करे। अब सवाल आता है वो कॉम्पिटेंस कहाँ से आएगी पार्लियामेंट? तो आप हम एंट्री 55 में चले जाते हैं कि ऐसी पावर वो दे सकता है कि नहीं। अब इसको जरा ओवरऑल स्कीम में देखिए कि हमारे पास ये जो सेक्शन 7 पढ़ा जा रहा था ये वगैरह, हमारे पास अर्जेंट लगते हैं, कितने लगते ही नहीं केसेस। ये आम रोजाना की एक शिकायत है कि अर्जेंट केस सुप्रीम कोर्ट में लगता ही नहीं है। चीफ जस्टिस साहब नहीं लगाते कोई केस, चीफ जस्टिस अपनी मर्जी का एक बेंच बना के कोई केस कर देते हैं। अच्छा, फुल कोर्ट नहीं बैठता, अवाम के केसेस हैं, अवाम का एक पूरा फोरम है पार्लियामेंट, वो अवाम कह रही है और वो पार्लियामेंट कह रहा है कि भाई अपने सिस्टम को ठीक करें और आपका सिस्टम 14 दिन में एक अर्जेंट लगाए। ये बात गलत हो गई। हमें करना है, हम सो जाएं, हम ना बनाएं केस, हम कोई केस ना लगाएं, हम अपनी मर्जी के बेंचेस बनाएं, ये ठीक है। पार्लियामेंट जो उसी अवाम के जिनके मुकदमे सुनने हम बैठे हैं, वो कहता है कि ये सिस्टम बना दिया है प्रोसीजर, 14 दिन में अर्जेंट केस लगाओ, तो हमारी पावर पे और इंडिपेंडेंस पे कतगन आ गया है। इसलिए कि हम 17 अनइलेक्टेड आदमी जिस तरह मर्जी अवाम के केसेस फैसला करें, लेकिन अवाम जो पार्लियामेंट के थ्रू हमें बताए वो हमारे रास्ते में रास्ता आ गया। 55 एंट्री, सारा सवाल एंट्री 55 का है। एंट्री 55 में सप्लीमेंटरी पावर्स दे सकते, उसमें बताइए कि क्या गलती है। सिर्फ इतना सा सवाल है।
It's your lordship, allow me a breather.
सदीकी साहब एक सवाल,
I will answer all these questions.
बिस्मिल्लाह कीजिए।
सदीकी साहब सांस ले,
My lord, I would answer all these
सांस
questions.
लेने से पहले एक सवाल और नोट कर लीजिए। देखिए, कॉन्स्टिट्यूशन ने कहा है,
खड़ी ना जाए।
कॉन्स्टिट्यूशन ने कहा है कि इंडिपेंडेंस ऑफ द सुप्रीम कोर्ट, nowhere it is mentioned that the supremacy or independence of the Chief Justice.
I would
एक
tend to,
मिनट,
I would answer this question.
एक बात
सर मुझे लगता है सारे मेरे कोलीग मेरे खिलाफ हो गए हैं।
क्वेश्चन पूरा नहीं हुआ। तो कॉन्स्टिट्यूशन सेज इंडिपेंडेंस ऑफ द सुप्रीम कोर्ट, जबकि रूल्स के तहत चीफ जस्टिस को पावर दिया।
चेंज कर दे सर,
एक मिनट,
रूल को चेंज कीजिए।
सुन लेना सर, रूल के तहत अब रूल क्या होंगे? अगर आप 191 पढ़ेंगे, आप वो रूल बनाएंगे जो कॉन्स्टिट्यूशन और कानून के ताबे है। ऐसा होगा कि रूल
स्ट्रगल सर ये हो रही है माय लॉर्ड, कि कह ये रहे हैं कि हमारा एक्सपीरियंस बहुत बुरा हुआ है पिछले अदवार में।
अच्छा,
And I don't want to comment on that.
इसकी
It is not my stature. It is not my function.
इसकी
I
कहीं
want my
और
lordship to be
ममालिक
seeing
में,
something out of the sky.
बात सुने प्लीज, इसकी कहीं मिसालें मौजूद हैं? किसी और मुल्क में कोई ऐसी मिसालें मौजूद हैं?
मैं उस तरफ आऊंगा अगर आप मुझे what the theme appears to be.
मैं अपने कोलीग से रिक्वेस्ट करता हूँ कि आपको इजाजत दें और आगाज कीजिए।
The theme appears, I just a sentence.
Just one question. आप सिर्फ इतना बता दीजिए, why 184(3? Why not 199 before the High Court? कौन सा fundamental right जो है
your lordships in a number of judgment have held.
जजमेंट तो बिल्कुल सही होती है सर। देखिए
आपको बताता रहा
कोर्ट के
हूँ,
सामने
आपको बता रहा हूँ, I have a
कौन सा फंडामेंटल
Sir,
राइट
I have a right to be dealt in accordance with the constitution and the law. It is my fundamental right.
Agreed.
And if I find that there is a deviation from the constitutional scheme, it is a question of violation of my fundamental right. And it is.
You tell us which one.
Which?
You can't just say it is. You tell us which one, we note it.
ये आप मानते हैं बिकॉज ऑफ जो पीछे पास में 2 डेकेड्स में हुआ है, इस तरह की रिफॉर्म्स आनी चाहिए थी।
100%.
100.
I am a victim of it.
एक सेकंड ना, अब ये अब लेट अस जस्ट इसको छोटा कर देते हैं। अब आप कहते हैं कानून बहुत अच्छा बना है, लेकिन पार्लियामेंट के पास इख्तियार नहीं था। हम अनइलेक्टेड जजेस जो है 15, हम बैठ के यही चीज कर ले तो ठीक होगा। तो फिर तो आप सिंपली आर्टिकल 191 के लैंग्वेज पे आ जाएं, सिर्फ उसी की इंटरप्रिटेशन आपको दरकार है। इससे मायने ये हुआ देयर इज नो फंडामेंटल राइट। आप कहते हैं कानून बहुत अच्छा है, आप खुद अफेक्टी हैं, यही चीजें होनी चाहिए थी तो हम खुद कर देते।
सिद्दीकी साहब, ये सवाल लिख कर रहे हैं आप?
पता नहीं,
हम तो बोल ही जा रहे हैं, आप हाँ करी जा रहे हैं।
साथी खड़े ये कोई काम नहीं
मैं सोच रहा हूँ कि आर्टिकल 10A, आर्टिकल 4
ऐसे नहीं कहेंगे। पढ़िए, एक पढ़िए और
I
बताइए।
will first read Article 4.
के बढ़ाते हैं।
I will first read Article 4.
For your starter, actually it is for your starter. आप ये whole of the act को ultra vires कहते हैं या कि there is any exception?
I find the entire act to be ultra vires the constitution because I feel this domain is not available to the parliament and the entire tenure of the section is unlawful. And I will show it to your lordship.
ठीक है, चलें।
Mr. Siddiqui.
Please your lordship, Article 4.
Mr. Siddiqui.
Article 4.
Please your lordship, I have another question.
Please explain whether any person of a society could lead a respectable life where the courts are not allowed to function independently?
No.
Is it not a violation of fundamental rights?
Yes. And that has been held by your lordships. It is not my, it is judgments of your lordship of 10 judges, 14 judges. And I just will never.
सवाल तो हमारे सामने ये कि ये जो कानून है ये तो और ट्रांसपेरेंट कर रहे हैं हमारे सिस्टम
Sir,
को
that-
और आम आदमी की जिंदगी आसान
सर
कर रहे हैं।
देखिए, मैं एक आपको मैं और वजाहत कर दूं। हम बहुत जजमेंट ओरिएंटेड बन गए। मैंने जो हल्फ उठाया है ना, मैंने ये हल्फ नहीं उठाया। सर सुन तो लीजिए ना प्लीज सर, कि मैं जजमेंट्स ऑफ द सुप्रीम कोर्ट का पाबंद हूँ। आप इससे मुखातिब हो जाए ना।
I'm with you.
कि मैं जजमेंट्स ऑफ द सुप्रीम कोर्ट के ताबे हूँ। मैंने हल्फ उठाया, मैं आइन और कानून के ताबे हूँ। प्लीज, मैं अपने हल्फ की वायलेशन नहीं करूंगा कि जी जजमेंट को, आइन को तो छोड़ दीजिए, आइन तो हम पढ़ेंगे नहीं, जजमेंट पढ़ेंगे बैठकर।
मैं तो कह रहा,
आप जरा सुन लीजिए ना, इस मुल्क में कई बार मार्शल लॉ भी लगे हैं, मैं उन जजमेंट के ताबे नहीं हूँ। आप सुन लीजिए वजाहत से, हो सकता है कोई और हो, मैं नहीं हूँ, ठीक है। आप 100 जजमेंट मुझे प्लेस करें, मैं एक भी नहीं पढ़ूंगा, मैं कहूंगा आइन पढ़िए। अगर आइन के वो इन अकॉर्डेंस विद है, यहाँ तो ये चीजें ना करें। रिमेंबर द हिस्ट्री ऑफ पाकिस्तान। हम लोग बैठ के लंबे लंबे आर्ग्यूमेंट्स कर रहे हैं, 57,000 केसेस एक्यूमुलेट हो गए हैं। तो अगर एक बेहतरी पार्लियामेंट समझती है, एक बेहतरी लाई है, आप फोकस ही नहीं कर रहे हैं इन्फोर्समेंट ऑफ फंडामेंटल राइट पे। वो ख्वाजा साहब चले गए, उन्होंने एक फंडामेंटल राइट का तस्करा नहीं किया। आपसे हम पूछ रहे हैं कि फंड 184(3) पे आ जाइए, फिर 191 पे आ जाइए, फिर आर्ग्यूमेंट्स करिए। बहुत बुरा कानून है, मगर उसके दायरे में लाइए।
I proceed.
जी प्लीज।
Article 4. I read, my lord.
फरमाइए।
To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person of the time being within Pakistan. In particular, no action detrimental to life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. B. No person shall be prevented from or hindered in doing which is not prohibited by law. And C. No person shall be compelled to do that which the law does not require him to do. Now let us go on to the.
Not go on to do, develop an argument.
Well, allow me.
No, why you read Article 4?
Your Lordship had asked me to argue the case according to the way that I want to proceed.
Yes, so please
allow me.
What is the violation of Article 4? What is the violation of Article 4?
My lord,
It is mentioned in the preamble of the Act.
I am making a submission to your Lordships.
क्या साहब जरा प्लीज एक चीज क्लियर कर दें, आप मानते हैं कि ये बेहतरीन कानून यही होना चाहिए, लेकिन आप कहते हैं कि पार्लियामेंट का इख्तियार नहीं था 191 में, यही प्रोपोजिशन। अब इसको जिस तरह माय लॉर्ड कह रहे हैं एक्सप्लेन कर दें। 191 पढ़ ले, उसमें अगर सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ है और सुप्रीम कोर्ट में है, शेल नहीं है, इट इज नॉट द राइट ऑफ द सुप्रीम कोर्ट। अब इतना बता दें कि जो सब्जेक्ट लॉ है, क्या वो रूल्स, उनका स्टेटस उस पार्लियामेंट रिप्रेजेंटेटिव बॉडी से हायर है या लोअर है? That's the only.
Thank you, my lord. I am indebted to my lord. This is the proposition.
एक आर्टिकल 4 आप कह रहे हैं, दूसरा कौन सा आर्टिकल है वो पढ़ लीजिए ना, सारे आर्टिकल के ऊपर आ जाए ना फिर आप।
आर्टिकल 10A,
आर्टिकल 10
पढ़िए।
आर्टिकल 10, sorry my lord. 9.
Yes, नहीं numbers ना दें, बताएं ना।
No person shall be deprived of life or liberty save in accordance with law.
आपकी कौन सी लाइफ लिबर्टी ले ली इस लॉ ने?
सर हमारे चीफ जस्टिस की पावर्स क्लिप कर रहे हैं।
तो मैं जानूं और पार्लियामेंट जाने आपका क्या ताल्लुक है?
No sir, that is my perception. If your lordship may be so inclined to, I'm going to persuade your lordship this is not a constitutional.
तो बहुत ही नोबल
आपने वैसे बड़ा जबरदस्त बहस की कि हमारे चीफ जस्टिस की पावर ले रहे हैं तो इंडिपेंडेंस ऑफ जुडिशरी और आर्टिकल 9 इफेक्ट हो गया।
Yes, the deviation is that a procedure other than the rules of the.
जैसे मैं वजाहत करना चाहता हूँ, मैंने आपको अपना वकील नहीं किया था। शुक्रिया। लोग ये ना समझ बैठे कि आपने मेरी वकालत कर ली।
I have to assist you the way the law in this country is.
चलते आगे ना।
सलीके साहब, एक चीफ जस्टिस आपके नहीं है, इस कौम के हैं और कौम के नुमाइंदे पार्लियामेंट में बैठे। उन्होंने कहा कि चीफ जस्टिस को ऐसे होना चाहिए, सुप्रीम कोर्ट को ऐसे होना चाहिए। आपने बताया
आइन को भी देख लेना पहले।
आइन तो कहते
आइन के देखे बगैर,
आइन तो कहते हैं सुप्रीम कोर्ट करेगा सब कुछ।
सर दिस इज व्हाट आई एम सेइंग।
तो आप तो कहते हैं चीफ जस्टिस।
नो आई से
आप अभी तक ये डिफरेंस नहीं क्लियर।
नो आई एम, अभी आप अलाउ करेंगे प्रोसीड करने तो
सब इन्फोर्समेंट ऑफ राइट्स
ना बड़े 4 हो गया, 9
कौन सी इन्फोर्समेंट करना
9 के बाद
10 में क्या है?
10 में कौन सा? नो, ये तो
no person who is arrested shall be detained. सर मुझे आप प्लीज
नहीं ये नहीं आपके, मैं सुबह से शिक 1 से शिक 260 तक पढ़ूंगा नहीं, सॉरी, ये जो हमारा टाइम है ना, इस पब्लिक मनी, ठीक है? आप ये नहीं कहेंगे मैं जो मर्जी आर्ग्यू करूं, आप उसकी हमें रेलेवेंस, सॉरी ऐसे नहीं आर्गुमेंट्स होंगे।
साहब जब आप मान गए हैं कि ये बेहतरीन कानून है, चीफ जस्टिस के इख्तियार जो कुली थे वो नहीं होने चाहिए थे, they were, उनका इस्तेमाल सही नहीं हुआ. अब उसके बियॉन्ड आप जाए, आप सिर्फ अब ये कह रहे हैं कि ये पार्लियामेंट का इख्तियार नहीं था. वो बता दीजिएगा.
मैं नहीं मान रहा कि ये बहुत अच्छा कानून है. मैं क्या ये इसका ख्याल बहुत अच्छा होगा.
आप चाहते हैं
कानून
आप चाहते हैं कि चीफ जस्टिस के पास कुल्ली इख्तियार हो.
मैं नहीं चाहता. आपने दिया रूल्स के अंदर.
नहीं वो आप उसको छोड़ दीजिएगा ना. हमने
छोड़ दी सर. आपने रूल
क्या आपके नजदीक एक शख्स के पास अनफेटेड, अनब्रिटल्ड, अनअकाउंटेबल, अनट्रेमल्ड पावर होनी चाहिए? यहाँ पे the power has been given to the chief justice and to senior most judges.
बहुत अच्छी बात है सर जो आप कर रहे हैं, बट कॉन्स्टिट्यूशन चीफ जस्टिस आपको बहुत पावर दे रहा है. लेट अस हैव अ लुक एट आर्टिकल 10. आर्टिकल 10 तो देख लीजिए सर.
एक सेकंड जरा इसका फॉर्मेट ठीक कर लेते हैं. सिर्फ हमें पहला सवाल हम पूछ रहे हैं कि 184 में आने से पहले फंडामेंटल राइट्स वाजे कर दें, कौन सा वायलेट हो.
योर लॉर्डशिप held that when a law is made or election is taken which violates the constitutional scheme, it is a violation of fundamental right.
तो स्कीम में कौन सी प्रोविजन बताएं ना
सर. मैं आपको, आप मुझे लागू करेंगे
इजाजत बताइए.
the law, the constitution requires, under the constitution, and I will read the relevant article to some breather by your lordships, that in the context of the trichotomy of powers, the parliament will make its own rules, the executive will make its own rules, the Supreme Court will make its own rules for functioning, and those rules have a constitutional force and they are of a higher pedestal than the ordinary law. This has been.
हमने जो आपसे शुरू किया था हकूक की बात, अब वो आपने तर्क कर दी. आप जवाब ना दीजिए प्लीज. आप आर्ग्यू कीजिए, हम आपकी आसानी पैदा कर रहे हैं, बाद में जवाब दे दीजिएगा. क्योंकि आप देखिए, मैं भी वकील रह चुका हूँ. जब 6-7 सवाल आते हैं बड़ा मुश्किल होता है. ठीक है, अब आपने पहले जवाब दे दिया था, बिल्कुल कानून सही है. अगर जब माय लॉर्ड ने सवाल दोबारा पूछा, अब आपने ठहर जाइए ना. जैसे विटनेस कहता है ना, अगेन सेज, जिसको डिस्कार्ड कर दिया जाता है. तो हम आपको बचाने की कोशिश कर रहे हैं कि आप सुन लीजिए, आर्ग्यू आप कीजिए, आपका केस है, मगर बताएं बुनियादी हकूक कौन सा सलब हो गया, ये बता दें बस.
अगर आप ये अगर को एप्लीकेबल करने के लिए पहले हमें बता दें कि कौन से फंडामेंटल राइट को इन्फोर्स करना चाहते हैं जो इनफ्रिंज हुए हैं. पहले इस पे आइए, ताकि व्हाई नॉट 199, यही पावर हाई कोर्ट के पास है, वहां क्यों नहीं गए.
सर मैं आपको नोट, I am asking your lordship to recognize my fundamental right given in Article 9, 10, 10A. सर मैंने पढ़ा, आपके सामने. बस यही आर्गुमेंट आपका. सर मैं पढ़ रहा हूँ आगे.
आप बताइए नहीं, प्रोपोजिशन ही डेवलप कर रहे हैं आप.
My proposition, मुझे आप, my proposition is that the legislature is bound by the scheme of the constitution, and the constitution requires that the constitution requires that the legislature will make its own rules. The constitution requires
a petition. ये आपने अभी बात की, मैंने नोट कर लिया.
3 different organs of the state. They will function independent of one another. One will not make encroachment on the other.
तो यहाँ तक पहुँचने में हमने बुनियादी बातें तो पता है ना, आगे बढ़िए ना.
It is my fundamental right to ensure and protect that this constitutional encroachment is not made by the parliament.
ठीक, समझ गए. अगला point.
And there are judgments on the issue which says that these are issues of fundamental violation of fundamental right, deviation from the constitution, and if it affects a large community of people, then it is a question of public importance. और जजमेंट है, आप नोट कर लें. मैं सर जजमेंट पढ़ने में चाहूंगा, दिस सो फंडामेंटल क्वेश्चन. ये देयर आर न्यूमरस जजमेंट्स.
ये इस बात का तयन करना
जी
आपके पास इख्तियार है. जैसे मंसूर शाह साहब ने जिक्र किया कि ये इख्तियार एक्सप्रेस होता है, या तो हम रेफरेंडम करा लें, जहाँ हर मार्शल और डिक्टेटर को 98.6% वोट हमेशा मिलते हैं।
अच्छा, 90
तो सुन लीजिए ना जरा, प्लीज तसल्ली रख लें
जी
ना।
सर, नहीं सुन लो।
या हमें क्या पता लोगों को क्या चाहिए, उसकी अक्कासी उनके नुमाइंदे, इलेक्टेड नुमाइंदे करते हैं, ठीक है, जिसको इलेक्ट करें उनकी मर्जी है, वो उसकी अक्कासी करते हैं। हम यहाँ तो कोई पोल अगर हम इधर खड़ कर मैं पूछ लूँ सबसे कौन से फेवर ऑफ दिस लॉ है, आपको कौन हक देता है ये करने का? आपको ये देता है कि फंडामेंटल एनफोर्समेंट ऑफ फंडामेंटल राइट्स की बात करें, आप वो बात ही नहीं कर रहे हैं। आपने बस 8, 9, 10 बस कोई आर्गुमेंट डेवलप कीजिए। हजूर ऐसे नहीं हुआ आर्गुमेंट।
योर लॉर्डशिप्स हैव हेल्ड।
इम्तियाज साहब, एक दफा फिर एक चीज क्लियर कर, अगर ये कानून सिर्फ चीफ जस्टिस के इख्तियार को डाइल्यूट करता है, आप समझते हैं कि ये अच्छी चीज है?
ऑब्जेक्टिव अच्छा है, प्रोसीजर अनकॉन्स्टिट्यूशनल है।
एक सेकंड, इसका मतलब है इससे आपके और पब्लिक के फंडामेंटल राइट्स इन्फोर्स हो रहे हैं। सेकेंडली, अगर राइट ऑफ अपील दिया जा रहा है, वो भी बहुत अच्छी बात है, उससे वायलेट नहीं हो रहा है, उससे इन्फोर्स हो रहे हैं। तो अब
आइन को मद्देनजर रखेंगे कि नहीं?
सुन तो लेना। अब आपका सिर्फ क्वेश्चन ये रह गया है कि जी ये बहुत अच्छी चीजें हैं, आप अनइलेक्टेड जजेस कर ले, लेकिन वो पार्लियामेंट नहीं कर सकती थी। भले आप रिफ्यूज भी करें, वो फिर भी बेबस है। चले हम आपकी ये भी बात
बेबस नहीं है।
एक सेकेंड, अब आप बता दीजिए कॉन्स्टिट्यूशन में एग्जैक्टली 191 पढ़ लीजिएगा, इसका मतलब है नो फंडामेंटल राइट।
मुझे अभी तक आपने ना आर्टिकल्स दिए हैं, ना मुझे सबमिशन करने दिए।
बताइए प्लीज बताइए।
आर्टिकल
4, 9, 10, 10A
फंडामेंटल राइट जो है उसको हम इन्फोर्स करना चाहते हैं। सर वो पढ़िए प्लीज।
सर मैंने आपको कहा है कि when due process is not followed in making a legislation by the parliament, forget about the objective. And if I am able to demonstrate to your lordships that a constitutional deviation has taken place, then the question of fundamental right violation occurs. Whether it occurs in rem or in personam is the next question.
अब समझ आई आपकी बात। वो ये कि कानून का ऑब्जेक्टिव तो शायद आम आदमी के लिए अच्छा है, लेकिन प्रोसीजर जो अडॉप्ट हुआ है ये हमें बताना चाहिए था, पार्लियामेंट ने क्यों बना दिया, ये सवाल है।
अब ऑब्जेक्ट
is not access to justice fundamental right now recognized as such?
Yes, it is.
Not independence of judiciary an integral aspect of access to justice?
Indeed, it is.
Therefore, is not independence of judiciary itself a fundamental right?
It is.
Is not independence of judiciary a salient feature of the Constitution?
It is.
Held by full court. Do you think every time the full court sits, that allows the Supreme Court, sitting as full court, to reset in the entire constitutional scheme?
It would be unfortunate unless it is done with valid reasons.
In a system based on the common law UK tradition, is it just the black and white language of the Constitution that is constitutional law, or is that embedded in constitutional law as developed by the case law? In relation to the US Constitution, it is said that 9/10 of US constitutional law is not written in the US Constitution. And sitting as a full court, each time a full court is constituted, is that like a tabula rasa, a blank slate, that we can write on it whatever we want and disregard settled law, fundamental rights? Is this within the power even of a full court? If we are to do that as a full court, disregarding previous precedents, then surely we have to have some weighty reasons to declare, for example, today that independence of judiciary is not a salient feature of the Constitution. That independence of judiciary is not a fundamental right. If it is not a fundamental right, out goes access to justice. It's not a question of speaking for myself, but putting it as a question to you of whether it is the Chief Justice or the 3-member committee. Who is Parliament to say it's a 3-member committee? Why shouldn't it be a 5-member committee? Why shouldn't it be a 7-member committee? If the answer is that the Supreme Court means the Chief Justice and all the courts, then Parliament should have made a law saying this committee shall constitute of the Chief Justice and all the judges of the Supreme Court. That is, they are the ones who will decide whatever is written in Section 2 and whatever is written in Section 3. Can Parliament pick and choose? Can Parliament say, no, judges is okay with us. 5 judges is too much. 1 judge is too little. These are aspects that go to the independence of the judiciary. Today, Parliament says not less than 5 judges to hear interpretation. Section Section 4. Tomorrow, Parliament says, "Ji, ek law bana deti hai ji. I don't know. Family matters are to be heard by a bench of less than 7 judges." Is that part of access to justice? Is that part of independence of judiciary?
It is.
Fundamental rights. Fundamental rights. अभी आप देखें अमेरिका में कितना वो बना हुआ है, वो जो है आपका राइट ऑफ अबॉर्शन, वो कहाँ लिखा है कॉन्स्टिट्यूशन में? लिखा है उनकी कॉन्स्टिट्यूशन? नहीं लिखा था, वो राइट दे दिया, पेनम्बरा में आ गया ना। उसके बाद उन्होंने कहा वो ओरिजिनलिज्म पे लोग जा रहे हैं कि जी बस आप देखिए उसके अल्फाज में लिखा है तो लिखा है, वरना नहीं लिखा, और वो भी जो 200 साल पहले की इंटरप्रिटेशन है। Is this the state of the law in Pakistan?
It is not.
Is this the state of the law in terms of even full court judgments? But as a full court, as the Supreme Court, as the defenders of the Constitution, the question is, are we to allow any erosion of independence of judiciary, access to justice, and would that not be the grossest violation of fundamental rights?
My lord, with respect,
अगर देखिए सिद्दीकी साहब, मुझे अभी तक आपके खूबसूरत दलाइल से मैं मुफीद नहीं हो पा रहा हूँ। आप जरा अपने दलाइल अपनी मर्जी से कर लें, आप सवाल नोट कर लीजिए, आप हर चीज पे कमेंट, आप अपना दलाइल तो देना चाह, फिर आप कल आप कहेंगे कि मेरे दलाइल ही नहीं सुने जा करके। आप चलें थोड़ा बढ़ा लें आगे बात को।
With great respect to my brother, independence judiciary is not just the external aspect. The most important is internal independence and institutional independence. अब आपने concede कर लिया कि this is a law which actually secures the internal and institutional independence. So, अच्छा law है, internal और institutional independence क्या होता है? अगर एक चीफ जस्टिस के पास इख्तियार हो और वो इख्तियार इस्तेमाल हो सके to achieve certain outcomes in cases and by constituting benches, that is a complete erosion of independent judiciary. And this is an aspect which this court has never taken into consideration. So that is, दुनिया भर में, this is the most important aspect of independence of judiciary.
आपको पता है बाकी मुल्कों में क्या होता है? जुडिशियल कैलेंडर स्टार्ट होने से पहले फुल कोर्ट बैठता है और वो बैलेट से बेंचेस बनते हैं, चीफ जस्टिस नहीं बनाता। और बाहर अगर आप ये बात करें कि चीफ जस्टिस बेंच बनाता है तो वो शायद इस बात को एक्सेप्ट कर सकते हैं, या बैलेट होता है या रेफल। कंट्रीज लाइक नेपाल, स्टार्ट ऑफ द कैलेंडर ईयर पहले बैलेट होता है कि बेंचेस कैसे होंगी। चीफ जस्टिस का कोई इख्तियार नहीं कि केस आज आया है और कल मैं अपनी मर्जी का एक बेंच बना दूं इस केस को सुनने का, जिसको मर्जी में बिठा दूं। ये चीजें, तो ये सारा कानून जो है ये वाजे कर रहे हैं इन चीजों को, इंडिपेंडेंस को तो बेहतर कर रहा है, स्ट्रॉन्ग कर रहा है।
आपने रूल्स बनाए हैं, उस रूल्स की बात की जा रही है, आपकी जजमेंट अपनी है।
जवाब दे, आप दलाइल नहीं देना चाहते हैं, आप जवाब ना दें, दलाइल दे दें।
आप इस तरह कीजिए कि आप अपने दलाइल
एस्पेक्ट अभी जो आप बात कर रहे हैं,
आप अपने दलाइल मुकम्मल कर लें।
वर्ड आर्टिकल 191 में लफ्ज़ लॉ लिखा है, whereas for example in relation to the review jurisdiction उसमें act of parliament लिखा है। It seems to me that even now if you go literal text of the constitution, that there is presumably a difference between the two, and law is in a common law tradition like Pakistan is well understood to mean statute law and judgment or case law.
Yes.
Now, Article 199 sets apparently a hierarchy. First is constitution, fundamental right, independence of judiciary. Next is law. Now, if law means, there's a question to you, if law means statute law and case law, the two are then co-equal because both are incorporated in law. So the question that strikes me is that this whole principle, rule, whatever you want to call it, that the Chief Justice is the master of the roster, in fact, is not in Order 11. It is given in judgments of the Supreme Court, in law. So the question therefore is, can Parliament, which is operating at the same level, law co-equal, can Parliament make, in the context of Article 191, and this goes to Section 8 of this particular law, can it make a law overriding in relation to the practice and procedure of the court, judge-made law, which is at the same pedestal? Can they do that?
No, they cannot.
Seems to me that even if we literally look at Article 191, perhaps it is unconstitutional.
जैसा फिर अगर आपको कोई दलाइल नहीं देना है और नहीं सुन लीजिए ना, आप तो हर के जवाब ही दे रहे हैं, आप अपनी पिटीशन तो आर्ग्यू नहीं कर रहे हैं, मुझे नहीं लग रहा है। आप कोई दलाइल आप दलाइल देके खत्म कर रहे हैं, फिर आपसे सवाल पूछ लेंगे, आखिर में हमारे जहनों में होंगे, ठीक है, या हम अपने जजमेंट्स में लिख देंगे, हर जज अपनी राय लिख देगा अपनी मर्जी से। आप प्लीज अपने दलाइल दीजिए।
May I proceed on?
जी प्लीज।
Sir, I'll only make one observation. It is settled law by law that the Parliament has the power to make our judgments ineffective. And this is a precedent which is embedded in our constitution.
If they are lawfully empowered, if the Parliament is lawfully empowered, not otherwise.
फिर आप बहस करने लगे।
But surely that
आप सुन तो लीजिए ना बात को, फिर आप नोट कर लें भाई, आप आर्ग्यूमेंट्स होते हैं, आप जज नहीं हैं, आप हर चीज का मैसेज जवाब दे रहे हैं।
May I proceed?
प्लीज डू सो। आप चलें, शुरू कीजिए, बिस्मिल्लाह कीजिए।
My learned brother asked you, surely that rule that Parliament can override judgments of the Supreme Court does not apply to a judgment which is interpreting constitutional setting or interpreting the Constitution or setting or establishing constitutional law. That only either can be done by constitutional amendment or if the court itself revisits that view. I thought that was also settled.
Yes.
So देखिए साहब जरा एक क्वेश्चन, आपका कहना ये है कि 3 members अगर बैठ के बेंचेस बनाएंगे एज पर दिस लॉ, तो ये इंडिपेंडेंस ऑफ जुडिशरी पर के खिलाफ है। तो क्या हम 17 जजेस बैठकर जब रूल बनाएंगे, हम कोई ऐसा रूल बना सकते हैं जो जुडिशरी की इंडिपेंडेंस को लेके एक शख्स के हवाले कर दे, या ऐसा रूल बनाए जो कॉन्स्टिट्यूशन के, क्या हम ऐसा कर सकते हैं?
सर कर तो सकते हैं, आपने अगर एक बंदे को
अनलिमिटेड पावर्स है माय लॉर्ड।
Just one minute. May I request my brothers, इनको बहस तो करने दीजिए, हम सब सवाल बाद में कर लेंगे। आप प्लीज अपने हिसाब से अपने आर्गू कीजिए।
Mr. Siddiqui, if I may just add, it is not a question of ये law गलत है या ये law बुरा है या अच्छा है. The fundamental question here is of competence.
Yes.
Who is competent to make whatever it may be called the rules of the law? If
ये तो आपने आर्ग्यू नहीं किया अभी तक।
तो मैं ये तो कह रहा हूँ,
आप हमें रोकें, आप कहें मुझे आर्गुमेंट सुन लीजिए।
मैं तो कह रहा हूँ कि कॉम्पिटेंस नहीं है पार्लियामेंट।
आप बताएं ना, हमें शिक दें कायरीन की।
डायरेक्ट उसी पे आ जाना,
इसी पे आ जाए, यही सवाल है।
देखिए मैं आप देखिए, आप हमसे ज्यादा समझते हैं, वकील हैं, यकीन हम लोगों की अपनी अपनी राय हैं, ठीक है।
मुझे आप
जरा सुन लीजिए ना 2 मिनट जी। वो हम अपने, अगर हम एक दूसरे से इत्तेफाक नहीं करेंगे, अलग अलग राय लिख देंगे, ठीक है। मेरे हिसाब से मुनासिब नहीं है कि हम सवाल के तौर पे अपनी राय आपको दें और फिर कोई हम दूसरा जवाब दें। हम सिर्फ सवाल पूछ लेंगे आपसे, आखिर में अब अपने दलाइल दे दीजिए, हम उसको नोट कर लेते हैं। हमें पसंद नहीं आए तो फिर हम सवाल, इतने पसंद आए शायद सवाल ही ना पूछें, नहीं पसंद आए 2-4 सवाल पूछ लेंगे। अब आप बिस्मिल्लाह कीजिए जी।
the concept of trichotomy of power is a concept well known to your lordships. The Constitution, what are those provisions which relate to the trichotomy of power? And let us have a look at them. With reference to the Supreme Court, have a look at Article 176, my lord.
Ji.
Article?
Article 176.
जी, पढ़िए.
My lord, Article 176 says, the Supreme Court shall consist of a Chief Justice, to be known as the Chief Justice of Pakistan, and so many other judges as may be determined by Act of Majlis Shura, Parliament, or until so determined as may be fixed by the President. What this article says is that one of the first steps in the appointment of the Chief Justice is the centrifugal force, is the linchpin, and once he's appointed and the rest of these members are not appointed, the Supreme Court will be there. And then the judges will be appointed.
Please, chaliye na, don't state the obvious, it's written there. देखिए, this is
नहीं, आप
really,
तो
no,
यही तो
sorry
कि
to
मुझे
say,
अफसोस हो
आपको पता है अवाम कितनी पैसे खर्च कर रही है.
सर,
हमने
मैं
ये आप
अवाम की खिदमत के
ऐसी
लिए-
बातें तो ना करें हजूर.
सर, आप मुझे आर्ग्यू, आप एक तरफ कहते हैं आर्ग्यू करें, दूसरी तरफ आप मुझे
आप कह रहे हैं ये आपने पढ़ लिया.
I am interpreting, I am just
Don't
giving
need
your
interpretation of the obvious. Supreme Court comprises of Chief Justice and Judges of the Supreme Court. Obvious.
No, it is not.
It's not.
It is not.
But
I am giving you, your lordship, a circumstance that let us assume, to understand the dynamic of Article 176, that assume there's a Chief Justice and there's no other judge. The question is, will the Supreme Court come into existence? The answer is
I
yes.
will not answer your question.
It
We are
will-
not
I
here.
am answering-
We
I
are
am
not here in a
answering.
theoretical realm. Please don't. No, now this is
will.
not fair. We are not here in a theoretical realm to
Let
discuss
us proceed.
what may or may not
Let
happen.
us
We are
proceed.
faced with a particular law. You challenge that law. Argue that case.
Let us proceed further. Let us go to Article 87. Article 87 relates to the Parliament and the Senate. Each house shall have a separate secretariat. It is provided that nothing in this clause shall be construed as preventing the creation of posts common to both the houses. Sub-Article 2, Majlis Shura Parliament may by law regulate the recruitment and condition of service of person appointed to the secretarial staff of either house. Until provision 3, until provision is made by Majlis Shura under clause 2, the speaker or as the case may be, the chairman may with the approval of the president make rules regulating the recruitment and conditions of service of person appointed to the secretarial staff of the National Assembly or Senate. So this is the rule making power. Let's go to Article 67.
I will not allow it, and I might even start imposing costs. Let's go here, let's go there. What's the relevance of Article 187? Don't do this. Sorry, please don't do this. Please don't do this.
It shows that the Parliament as a separate organ of the state
Profound.
has the power to make rules for its internal working. And this is the theme which is contained in Article 67.
No. ये रूल्स सिर्फ बनाएंगे किसके लिए? सेक्रेटेरिएट
हमने तो नहीं बनाए लिए।
अपॉइंटमेंट के लिए,
Constitution-
रिक्रूटमेंट के लिए और उसके लिए तीन चीजें लिखी हुई हैं साथ।
सर, मैं आपको शो ये करना चाह रहा हूँ कि पार्लियामेंट का अलग सेट ऑफ रूल्स है, एग्जीक्यूटिव का अलग है, सुप्रीम कोर्ट का अलग है, और ये रूल्स जो हैं
आप
ये
सुप्रीम कोर्ट वाले पे आ जाइए ना. हम पार्लियामेंट के रूल जब वो चैलेंज करेंगे ना, आप कि उन्होंने गलत बनाए वो देख लेंगे. अभी आप सुप्रीम कोर्ट पे आ जाइए. बस
सुप्रीम कोर्ट के रूल्स हैं आर्टिकल 191.
उसकी तशरीह कर दें, खत्म.
Subject to the Constitution, and law. The Supreme Court may make rules regulating the practice and procedure of the court. Now, the law is a word which is different from the act of the parliament. It may,
Law is different from act of parliament.
yes, it is. Law is
So
a
this
large-
is something I've never heard before.
Yes, sir. May allow me to assist you. Law encompasses a lot of other things than the act of the parliament. Law includes within itself usage having the force of law. Refer to Article 8.
यहाँ तो
In
law
the
आ गया।
in the same sentence, the parliament, Ain has used constitution, law and rules.
Sir,
And please, I'm not going to expect this kind of argument for the Supreme Court. Sorry, this is not on.
I am
नहीं,
giving
देखिए,
your
आप
lord-
ऐसे
no, I'm
arguments ना
giving your
कीजिए।
lordship extraordinarily good argument. If your lordship is inclined to ridicule me like that, I will not pay, I will withdraw from the case. I don't
Imtiaz Saab.
I don't allow this.
Please,
Imtiaz
that's your
Saab,
choice.
Your
Imtiaz
lordship
Saab.
has constantly
Imtiaz Saab.
thwarted my arguments again and again. Have a patience to hear my arguments.
तो ये बताइए जो बेचारे लोग जेल में पड़े हुए हैं ना, एक
छोड़ दे सर,
छोड़ेंगे नहीं हम
मैं
छोड़ेंगे।
बचा रहा हूँ, मैं से ही हूँ।
हाँ नहीं,
मैं भी नीचे
उनके
से
cases
बैठ के
कौन
बोल रहा है।
फैसला करेगा? एक चीज होती है अमेरिकन आइन में, वो लोग करते हैं क्या होता है, फिलिबस्टरिंग, कि जी चलते रहो। अगर आप समझ रहे हैं कि इस तरह से
मैं ऐसा कर ही नहीं रहा।
अब आप
अभी आपने मुझे
अब आप बोलने आप हम सुनते हैं मगर आप हमारी बात को सुनना पसंद नहीं फरमाते हैं।
सर,
तो ये
ये बात आधे घंटे से सुन रहा हूँ।
चलें।
If I've got
Sir,
you correctly, if
Sir.
I've got you saying that law is not only the act of the parliament,
Yes.
because there are rules of 1980. If there were no rules, fine, they could have enacted that law. Because they have the rules of 1980, so that's why they were not empowered to pass
My lord,
any law which was contrary to it.
I would not go to that extent. Assume there are no rules. The question is whether the parliament can frame this law or not is a question which probably is not free from doubt. I would still say the parliament can't do it. The rules are imperative.
So
If your lordship would look at Article 8,
आप फिर ये
if your
कह
lordship
रहे
would look at, if your lordship would look at
हैं-
Article
एक
8.
सेकंड, इम्तियाज साहब,
Sir.
ये सिंपल हो गया है। आप ये कह रहे हैं कि इस आर्टिकल में एक्सप्रेशन लॉ जो इस्तेमाल हुआ है, this excludes an enactment of the parliament.
No, my lord, I'm not saying this at all. I say law has a larger composition than the act of the parliament.
So we are, at this moment, we are only concerned with an act of the parliament.
Your lordship has asked me a question, what is the scope of the word law?
Yes,
And I'm trying to assist your lordships.
In this case,
is
it's
this
not
the law or
relevant
not?
because the law has already come.
My lord,
Question आपने सिर्फ
I
बताया
am saying that this law,
सब
to
अपनी
us,
इंसान
your lordship's assumption is that since the word law has been used in Article 191, therefore the parliament can make
फिर
this
आप
law.
उसमें जाने-
I am trying to show to your lordship, it is not the case.
See, I'll take you back to my original question,
Please, Lordship.
where under a constitutional power, this court has framed rules. Do they stand on a higher footing than ordinary legislation?
Yes, my lord, there are judgments to that effect rendered by your lordships.
Can I ask a question as well? When the Constitution makes a distinction in different articles using the Act of Parliament and using the word law, so how do you see that distinction? So for example, in 191, they could have said subject to the Constitution and Act of Parliament, but instead of saying that, they've used the word subject to the Constitution and the law. There are other provisions of the Constitution which don't use the word law, but use the word Act of Parliament. So there is a clear difference between an Act of Parliament and the word law. So what do you understand by the word law? Because this provision of making rules is subject to the Constitution and the law.
So in
Adding
essence,
that,
the framers of the Constitution were conscious of the distinction between an act of the Parliament and the law. While they envisaged that law includes judge-made law and other variations of the law, Act of Parliament was specifically used in a particular sense. And they can't be used interchangeably.
and whether this enactment Act of Parliament cannot be considered as law.
My
Is it
lord,
not a law?
in ordinary parlance, there may be impression.
No, I'm talking specifically
But
about this.
within
Whether this is law.
context of Article 199,
This is not law.
it is the constitution and law. It would mean law in a broader context. And what are those? Laws which are protected under Article 270AA. Usage or customary practice having the force of law in terms of Article 8. And judge-made law, the judicial precedents which your lordships have given time to time to the people of Pakistan to show to them what law is.
I got your point. You say that every usage, custom can be considered as law, but cannot be considered as act of the parliament.
Yes.
Whereas act of the can be considered as act of the parliament as well as law.
Yes.
So then it is not a law.
I am saying the context in which the word law has been used in the physiology of Article 191 manifests that this is not an ordinary act of parliament. It means the law which has been rendered from time to time in the form of judgments of the Superior Court.
Do you think, or are you arguing that it is the exclusive power of this court under Article 191 to make rules?
Absolutely.
And those rules, once that power has been exercised, whether by specifically making rules or through law that is judge-made law, ordinary legislation cannot override that because there is no legislative competence to do that in terms of item 51.
It is precisely my argument. I will go a step further.
Before you do that, that's very interesting. I was just recalling the equivalent provision in the Indian Constitution is Article 145 relating to the rules of the Supreme Court. Now, this has very interesting language. It is subject to the provisions of any law made by Parliament.
Yes.
The Supreme Court may from time to time, with the approval of the President, make rules, etc. So here, in relation to law, they are clarifying it is statute law or made by Parliament. Whereas in our case, it is just law. So the rules, the law includes any decision of the court which sets out the practice and procedure of the court. And to that extent, statute law cannot override it, cannot supplant it, cannot whittle it down until the court itself revisits that law on the judicial side. It cannot even be done by the full court sitting on the administrative side. I go back because there is a certain equivalence between what the court can do on the administrative side to make its rules and what Parliament can do maybe in terms of statute law. But it seems to me that use of, speaking for myself, the use of the word law includes case law or judge-made law. Even the full court on the administrative side cannot overrule that. So this rule, which is supposedly overruled by sections 2 and 3, master of the roster, that is judge-made law. And therefore, even the full court sitting on the administrative side can't do it unless the court revisits that principle on the judicial side.
Imtiaz Sahab, how will we read into this provision 191? It's a constitutional provision. We'll have to read into it that the law only means judgment law. फिर अगर आपका argument ले लिया जाए तो इस law expression से enactment is excluded, but even a usage or a custom override a rule made by all of us.
My Lord, my submission is as follows. Allow me just follow your Lordship's conclusion. My Lord, the Constitution as I read it, and I make submission with respect to your Lordships, the Supreme Court of Pakistan has held that notwithstanding the rules and the rules which are framed under the constitutional scheme, they are on a higher pedestal than ordinary law. Even conventions which have been judicially recognized by the superior courts are constitution by themselves, and the parliament cannot encroach upon them.
इम्तियाज
This
साहब,
is
Next point.
इम्तियाज साहब
Yes.
पहले इस फंडामेंटल उसको क्लियर कर दें. Do we have to read into the expression law that is, it is only confined to the judgments of this court and the precedent?
Your lordship will appreciate the contours of the word law, which has been used with reference to the constitution in terms of Article 181 and the scope of that word. And if your lordships come to the conclusion that this includes the case law rendered by the superior courts have said that even conventions, if they are proven before the court in the constitutional domain, they are the constitution themselves and violation cannot take place.
ये जो लॉ है आपके ख्याल में ये 191 में नहीं आता, ये किस कैटेगरी का लॉ है
ये कैटेगरी सर अनकॉन्स्टिट्यूशनल लॉ है, ये आते ही नहीं है.
In which category you will fall this law, because
This is act of the
Article 191, the definition of law is something else which you are trying to.
This is an act of the parliament. It comes out of the theme of the word law, and there are other sources
How
of
it
law.
is out of the word scheme of law? What is your argument on this point?
My argument is that to isolate the word law with reference to act of parliament alone.
What about Article 140 and 141? There is also the word law has been
Yes,
used.
what I'm saying this is that Article 141 and 142
Article of the Constitution in which the laws are made by the Parliament.
My
And
lord,
under Article 141, the law is mentioned. If it is not the law, then what is the category of this
My
law?
lord,
Because we are
Article
going to develop a new jurisprudence
No, my lord.
in this case. The
Article
third category of law.
Article 141 has to be read with the fourth schedule, and it cannot be read in isolation. What it means is that these are the laws which will be enacted through act of parliament.
No, if you will read Article 142, if you will read Article 142,
सिद्दीकी
the
साहब अगर
Majlis Shura,
सिद्दीकी साहब अगर कॉम्पिटेंस की बात है ना, कॉम्पिटेंस की अगर बात जो बार बार सवाल हो रहा है, तो एंट्री 55 और 59 को पढ़ लें, उसमें तो पावर है ना कि पावर्स में लॉ आ सकता है.
सर लॉ एनलार्जमेंट के लिए फॉर एग्जांपल
आगे बढ़े ना, इन सब पावर्स भी दे सकता है.
सर ये सप्लीमेंटल पावर नहीं
ये
है,
बहस आप
ये
कर सकते हैं.
इंटरनल वर्किंग को इंटरफियर किया जा
ठीक
रहा
हो
है.
गया, तो आप ये बहस करें ना कि ये सप्लीमेंटल पावर्स के अंदर है या नहीं, या एंसिलरी पावर्स के अंदर है कि
सर,
नहीं. आप तो कह रहे हैं लॉ ही नहीं बना
तो सर मैं बताता हूँ, मैं आपसे कह रहा हूँ कि अगर ये लॉ ये हो कि आपको फॉर एग्जांपल इलेक्शन एक्ट के तहत डायरेक्ट अपील दी जा रही है सुप्रीम कोर्ट में या सर्विस मैटर्स में दी जा रही है, तो वो इनलार्जमेंट ऑफ जुरिसडिक्शन होती है, लेकिन आपकी इंटरनल वर्किंग के अंदर लॉ फ्रेम नहीं हो सकता.
देखिए ना, एक सेकंड, बड़ा सिंपल सा सवाल है, अगर हम फोकस कर लें तो बड़ी जल्दी ये मामला हल हो सकता है. एक तो ये है कि लॉ इन्विजिज किया 191 ने, तो कानून आइन रिडंडेंट नहीं होता, कुछ चीज कानून ऐसा हो सकता है. उसी आइन के अंदर लिखा है कि 55 में सप्लीमेंटल पावर्स दे सकता है, 59 में लिखा है और एंसिलरी मैटर्स भी देख सकता है. अब आपने सिर्फ हमें ये बताना है कि क्या पार्लियामेंट ऐसा कुछ बना सकती है 55, 59 और भी शायद एक आध प्रोविजन एंट्री के तहत जो रेगुलेट कर ले अफेयर्स ऑफ द सुप्रीम कोर्ट.
सर
क्योंकि 191 इन्विजिज करता है कि ऐसा कानून हो सकता है, तो सुन लीजिए, तो वो कानून रिडंडेंट तो लफ्ज नहीं हो सकता ना 191 में. एक कानून ऐसा हो सकता है कोई जो रेगुलेट करे प्रोसीजर को, उसकी पावर 55 और 59 में दी हुई है. आपका ये बहस हो सकती है कि सर इसमें वो पावर नहीं निकलती फेडरल गवर्नमेंट, फेडरल लेजिस्लेचर की, वो आप बता दें हमें बस सीधा.
सर दिस item 55 first makes a prohibition.
वो हमने पढ़ लिया. मैं आखिरी लाइन
सर
की बात,
बिल्कुल आपने पढ़ लिया है, मैं भी सारी जिंदगी I've been rubbing shoulders with lordship. This creates an impediment on the word jurisdiction and power. इसके ऊपर तो full stop है.
इसको पूरा पढ़िए ना मिला के,
सर,
बिट्स एंड पीसेस में
jurisdiction-
पढ़िएगा, बिट्स
सर
एंड
मैं
पीसेस
दोबारा
में
पढ़ूंगा तो वो कहेंगे कि दोबारा पढ़ रहे हैं आप.
नहीं, इसमें आगे जाके
Jurisdiction and power of all courts except the Supreme Court. jurisdiction power पे नहीं आप law बना सकते.
आगे चलें.
With respect to any matter in the list and to such extent as is expressly authorized by the Constitution, the enlargement of jurisdiction of the Supreme
ये
Court.
बना सकते हैं ना.
Enlargement हो सकती है.
आगे
Enlargement के लिए भी there has to be a specific, ये जो language used है, specific authorization.
Yes.
Now where is the specific authorization?
नहीं, आगे पढ़े
You have
अगर
to
आपसे
read
आगे
it.
पढ़े enlargement
And the conferring thereon of supplemental powers.
सप्लीमेंटल पावर्स पार्लियामेंट लगा सकता है, दे सकता है सुप्रीम कोर्ट को.
Supplemental powers ये है कि आपको वो कह सकता है कि आप फाइनेंस से ये पैसा विड्रॉ कर सकते हैं, या आप ये लिटिगेंट को कोई अपील आई है तो उस पर ये टिकट लगा के पैसा सुप्रीम कोर्ट में डिपॉजिट हो सकता है. ये सप्लीमेंटल पावर्स हैं. वो ये नहीं कह सकते कि चीफ जस्टिस साहब अकेले फैसला नहीं करेंगे, हम नहीं मानते इस बात को.
पावर दे रहे हैं कि चार और
वो ये नहीं कह रहे, वो रेगुलेट कर रहे हैं पावर ऑफ द चीफ जस्टिस
इम्तियाज साहब
रिलेटिंग टू
इम्तियाज साहब
देर के लिए अलग भी कर दें तो वो एंड है, वो और नहीं है.
ये कह ये रहा है ये आर्टिकल 191. अगर आप आर्टिकल 191 को along with article 141 और 142 और item
I'm just asking article 191 जो मेन इशू है article 191 का आ रहा है ना, कहेंगे वो लॉ ये वो नहीं है, ये कोई और लॉ है. बट subject to constitution and law, whenever this law is used subject to, what is the interpretation of subject to?
सर सब्जेक्ट टू का मतलब है कि
जो लॉ में है वो रहेगा, इसके अलावा आपने कोई चीज बनानी है तो आपने रूल और भी आप बना
वो कह ये रहा है कि अगर ये कॉन्स्टिट्यूशनल स्कीम के अलावा अनऑक्युपाइड डोमेन है तो फिर आप इसके अंदर कर सकते हैं कोई फ्रेमिंग ऑफ लॉ. और वो ये है कि
आपकी बात का जवाब है ना, सब्जेक्ट टू कॉन्स्टिट्यूशन. चले कॉन्स्टिट्यूशन में तो अमेंडमेंट नहीं हुई, एंड लॉ, तो जो लॉ उन्होंने बनाया है वट एवर इट मे बी जो आप अंडर चैलेंज है,
यस,
उस लॉ के मुताबिक आर्टिकल 191 में वो लॉ बन सकता है या नहीं बन सकता है?
सर वो एनलार्जमेंट ऑफ जुरिस्डिक्शन के रेफरेंस से बन सकता है.
एनलार्जमेंट ऑफ जुरिस्डिक्शन बन सकता है.
बन सकता है.
उन्होंने क्या किया है?
उन्होंने चीफ
एक्ट के तहत उन्होंने राइट ऑफ अपील दे दिया आपको जो नहीं थी, रिव्यू को स्ट्रॉन्ग कर दिया, कमेटी बना दी. तो अब इसमें फंडामेंटल राइट्स की वायलेशन किधर है? ये है बुनियादी चीज आर्टिकल 184(3) में जो आपसे पूछ रहे हैं ना. दिस इज नॉट अ वायरीज अंडर आर्टिकल 199 ऑफ द कॉन्स्टिट्यूशन दैट कैन बी चैलेंज्ड इन द हाई कोर्ट, वेयर इफ यू कैन चैलेंज द वायरीज ऑफ द लॉ. बट हियर इट इज आर्टिकल 184(3). दिस इज द एनफोर्समेंट ऑफ फंडामेंटल राइट. राइट ऑफ अपील इज अगेंस्ट द फंडामेंटल राइट, देन ओके.
इम्तियाज साहब एक और चीज को गालिबन कंफ्यूज कर रहे हैं. There's a difference between इख्तियार of the Chief Justice and the jurisdiction and power of the Supreme Court. इस पूरे लॉ ने सुप्रीम कोर्ट के किसी इख्तियार को नहीं छेड़ा. It's only the Chief Justice, and the Chief Justice is Supreme Court.
सर इस लॉ ने आर्टिकल रूल 9 को ऑब्लिटरेट कर दिया है और आपने इंडिविजुअल लेवल पे जजमेंट दिए हैं जहाँ पे रूल.
एक सेकंड इम्तियाज साहब,
सर आप मुझे एक सेकंड ना दीजिए, मुझे सुनने मेरी बात.
सिर्फ चीफ जस्टिस का इख्तियार डाइल्यूट हुआ है ना.
सर आपने चीफ जस्टिस साहब ने खुद अपनी जजमेंट में कहा है कि रूल 9 जो है उसके तहत रिकॉन्स्टिट्यूट नहीं हो सकती जब तक चीफ जस्टिस ने कॉन्स्टिट्यूट कर दी हैं. और ये जजमेंट आने के बाद ये फील्ड अनऑक्युपाइड नहीं रही.
सुप्रीम कोर्ट में चीफ जस्टिस को सेपरेट किया जा सकता है फ्रॉम द अदर जजेस?
नो.
तो फिर कैसे रूल में सुप्रीम कोर्ट को अलग करके इख्तियार दिया गया?
सर आपने सरेंडर किया है, इख्तियार देना है कलेक्शन. आपने मुख्तार बनाया चीफ जस्टिस को कि हम चीफ जस्टिस की इस बात को हम ऑथराइज करते हैं.
क्या हमने कॉन्स्टिट्यूशन के मुताबिक किया?
सर आपने कॉन्स्टिट्यूशन के मुताबिक किया है. 180 में आप फॉलो करते रहे हैं.
जो जजमेंट
आपने जजमेंट दी है कि चीफ जस्टिस साहब बेंच कॉन्स्टिट्यूट करें.
जजमेंट्स की बात कर रहा हूँ, जजमेंट्स की बात कर रहा हूँ. जो जजमेंट्स आई थी वो इस एक्ट से पहले थी और वो दैट वाज बेस्ड अपॉन द रूल्स. अब एक्ट ज्यादा बड़ा है या बड़े?
सर आप जजमेंट तो पढ़ लें. तो आपने कहा है कि ये रूल्स जो हैं ये हायर पेडिस्टल पे हैं.
पर वो
ये आपकी जजमेंट है.
साहब आप फुल कोर्ट के सामने बहस कर रहे हैं, जजमेंट कितने मेंबर्स की है?
सर
जजमेंट कितने मेंबर्स की है?
10 members, 10,
हम कितने हैं?
14.
अच्छा इम्तियाज साहब
नहीं,
ओवररूल करना
इम्तियाज
पड़ेगा
साहब,
सर, रीजंस देके
इम्तियाज
ट्राई
साहब
नहीं कर सकते।
कर
इम्तियाज
सकते हैं, क्यों नहीं कर सकते, बट रीजन
इम्तियाज साहब इम्तियाज साहब
ठीक है
not that easy.
इम्तियाज साहब
Referring to the Binder.
I wish things were as easy as your lordship has put
इम्तियाज
it.
साहब
It is not.
इम्तियाज
Sir,
साहब
sir,
अल शमरेज केस के बाद पार्लियामेंट ने एक अमेंडमेंट की एक स्टैट्यूट में
Sir.
अल शमरेज केस का इफेक्ट खत्म हो गया
judgment को नहीं हाथ लगाया
वो हो उसका that law finished to an end and that is the authority of the parliament.
सर आप कोई और बात कर रहे हैं, वो
मैं
बात
और-
कानून की है सर. Allow me to assist your lordship.
You see, if this court interprets the law in a certain way, a law, an ordinary law, and the parliament changes that law, nobody has stopped them from doing that.
With retrospective.
Yes, the distinction here is that here, the rules which have been framed in 1980 in exercise of powers under 191, Article 191 of the Constitution, they are not interpreting any ordinary law which can be changed by ordinary legislation.
This is what my submission is, the same issue. That is the
This power has been exercised under the Constitution, and it says so specifically in exercise of powers under Article 191 of the Constitution of Islamic Republic of Pakistan. The Supreme Court makes the following rules. So it's not that there is one ordinary legislation which is interpreted by the Supreme Court and the Parliament says, well, we want to change the law, they can change the law. Because they had made the law, they can change it. Likewise, if the Supreme Court has made the rules and the Supreme Court decides to change them, so be it. That's gels in very.
That's the precise submission I'm trying to make.
With the doctrine of separation of and trichotomy of powers. It's as simple as that.
My lord, an event arose when my lord, the Chief Justice, the benches were reshuffled. And a judgment.
Argue kariye apna case.
And
आप अपना case argue करिए.
my case has been, allow me to give your lordship a judgment on the issue.
आप कितना वक्त और लेंगे?
15 minutes और दे दूंगा अगर questions ना हो तो. Lord, this is PLD 1998 Supreme Court 161. Malak Asad case.
PLD?
Malak Asad Federation of Pakistan.
This is page?
This is PLD 1998 Supreme Court 161.
Okay, Asad Ali.
Lord, the question was with reference to the entitlement of the senior most person to be the Chief Justice of Pakistan. And the question was there a convention? And if there was a convention, did it have some binding force? This was the question. The Supreme Court, I take your lordship on page 314, paragraph 95. We are inclined to agree with the conclusion that a constitutional convention once established has the same binding effect as a constitution. I don't want to read the rest of the paragraph. Your lordship has already said.
So now I have a question.
Yes.
Are you saying that the senior most judge of the High Court must be made because there's a convention, the Chief Justice, upon the don't interrupt till I finish the question. Upon retirement of the Chief Justice, have I understood you correctly?
No, my lord. Your lordship is not. Then your lordship will have to read the judgment. That judgment says that the senior most judge of the Supreme Court has to be appointed as Chief Justice because there's a convention and there's a past practice. And elaborate arguments have been given. And it
The
is,
convention in the High Court generally is to make senior most chief justice.
But
So it
this judgment
it
doesn't-
becomes constitution.
this judgment doesn't talk about the High Court. It talks about the Supreme
बात हो रही ना, असूल की बात हो रही ना,
Sir,
असूलों की बात हो रही है।
असूल वो है जो मेरे लिए जो जजमेंट में है, आप खुद बता,
अरे, वो क्या आगे
आप बता देंगे जो असूल उसके मुताबिक
आगे
चलेगी।
बताएं,
जी सर,
आगे बढ़िए।
Similarly, your lordship held that these rules of the Supreme Court are on a higher pedestal than the ordinary law. And
कौन सा जजमेंट है?
my lord, 2010, my lord.
Why the rules are at higher pedestal? Why?
Because these rules are, they have been made by a constitutional body and
Subject to law.
This is part of. the
subject to law की बात है।
साइटेशन तो दे दें 2010 2010
चल मैं भी दे रहा हूँ।
इम्तियाज साहब,
सर दे दें, मैं तक पढ़ लेता हूँ, आप बता दें।
this is a constitutional body and the Parliament Majlis Shura, that is not,
2010
which has
क्या है
the
citation?
exclusive power to make laws.
इसी में
Yearly 2010 SC 483. Winter का अलग केस।
इस जजमेंट में आप क्या बताना चाह रहे हैं हमें?
इस जजमेंट में कहा है कि सुप्रीम कोर्ट के रूल्स जो हैं,
कहाँ, किस पेज पे, किस किस पैराग्राफ में?
the relevant page is page 535
535
and it goes on to page,
नहीं, हमें रेलवेंट पढ़ दीजिए। 535 कहाँ लिखा है ये?
it goes on to page 536. The Supreme Court rules, देखना पसंद करेंगे सर किताब? The Supreme Court rules,
Page क्या होता है? Page क्या क्या?
page
Supreme Court rules are on high pedestrian promulgated on the basis of mandate given by the Constitution and not by the government. हाँ, so how does it say it's higher than a law? वो कहाँ लिखा है?
the Supreme Court rules on a higher pedestal and promulgated on the basis of mandate by the Constitution and not by the government. Objective thereof is to enhance the power of review as conferred by the Supreme Court rules under Supreme Court under Article 180 of the Constitution.
अच्छा, इसमें दो बुनियादी बात हैं जो आप कह रहे थे उसके बरक्स है, और दूसरी बात है whereof was to enhance the power of review.
सर,
तो ये तो enhance कर दिया था power of review ने।
सर ये क्या है, ये
लॉ का तो नहीं इसमें जिक्र, शायद कहीं और हो, मुझे नहीं पता।
नहीं सर, इसी जजमेंट को पढ़ें अगर आप डिटेल में, कहने मैं पढ़ना शुरू कर देता हूँ। इसमें
नहीं, ये काम नहीं होता है वकील का। वकील का काम होता है निशानदेही करे फलां सफे पे इस पैराग्राफ में, ये नहीं कि मैं पढ़ना शुरू कर देता हूँ। हमें डराएं नहीं, आप सिर्फ वजाहत कर दें। मैं पढ़ना शुरू कर देता हूँ।
पेज बता दीजिए प्लीज।
सिर्फ पेज बता दें, हम पढ़ लेंगे खुद। इस पे ये बात नहीं लिखी है जो आप कह रहे हैं। इस पे
536,
हाँ, ये मैंने पढ़ ली। चलें अगला बताइए केस।
PLD 1997 Supreme Court 426. अच्छा इस केस में लो।
PLD
PLD 1997 Supreme Court 426.
Relevant 1997
जी, सफा
511, page 511, 511. Page 511, 511. Significantly, by employing the word any law, the intention of the Constitution seems to be that Article A will apply to all laws made by the Majlis-e Shura Parliament, be it or any law to amend the Constitution. Likewise, no amendment can be made in respect of provision of the Constitution relating to judiciary by which its independence and separation from executive is undermined or compromised. These are built-in limitation in Constitution, completely independent from political morality and force of public opinion.
I can agree.
I will file a petition. I've not even heard. And 3 judges or 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, Section 3 is. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or make why not 7? Why not 6?
Please.
I
arguing-
object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just say, is this ultra vires the Constitution, Section 4? Say some.
Khaja Sahab, Section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो dictator का था वो दुरुस्त है और parliament appeal का right नहीं दे सकती? वहाँ तो appeal का right दिया है, same provision Constitution. Article 199, here Article 183, 84(3). तो ये क्या दोनों में?
Sir, it is not we also this thing that what Parliament can do and what Parliament can do many things. My Lord has said so. But there is a procedure provided. Will answer that.
भाई साहब अभी जो आपकी जरूरत नहीं है आप
I will not answer.
पहले एक्ट को खत्म कर
Section 5 से आप आगे पढ़ लीजिए. Khaja Sahab, you have collected 100 questions.
Just here. The Law Reforms Ordinance of
How you will
1972.
answer.
This is the question to you. Regulated right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clause is there only in respect of the Supreme Court. Law Reforms Ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent, which is now no longer there, and also the clause was only in relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clause.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will
What you have to do, you're not going to do it.
My lord,
You have challenged the
my
law,
lord,
you have
my
to do,
lord,
you have to challenge
that
it.
appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
My lord, as far as section 5 is concerned,
Is it good? Is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in clause 2? Whereby my 184.3 application will be disposed
But is that
of.
the way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it to them, because if I start explaining it as it will take your time. But I will say this thing, that this section 5 should have also, this right of appeal should also have been given in section 2.
Should is different from ultra vires of constitution.
It ought to have been given.
What then you go and move a bill in parliament. We are saying, are you opposed to section 5? Give us legal reasonings, or you say it's okay. उनसे आप पूछेंगे.
You have done this.
ये नहीं आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
इसमें to make it more simple, you don't want your client to have a right of appeal.
No, sir,
First say it's unconstitutional, it's constitutional. You're not saying anything, you just. यहाँ कोई discussion होता है. Sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the.
Please answer the question. Is this constitutional or unconstitutional? I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
It's my personal opinion is this, sir, that this section 5 goes beyond the powers which were there with the parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under section 184.3.
Okay.
And this appeal through this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions. Please let me finish. Please let me finish.
Yes, sir.
On the one hand, you are saying, where will I go? Where will I go? Here, the parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the right to appeal is given, but the manner in which it has to be given.
Please, take it.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the constitution.
It is unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184.3 is a substantive provision of the constitution. If
You are happy with no appeal.
If a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
I just have a question to you with regard to section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you has two parts. The first part is this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence conferred by Article 191 in relation to practice and procedure, confer a right of appeal? Because if I may, and this is the point, I apologize. My question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah said recently, that this is recently, meaning in the hearing of the case, that anything that this law does, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it, because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You
This
don't
is
have
my
to give
point.
you don't have to give an answer. Just note it down.
If the right of appeal had to be given, it should have been given through an amendment.
Note it down.
Yes, next is right to appoint.
आप चाहें आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्गुमेंट चलाते रहें, जी आगे बढ़ते हैं। छः को पढ़िए, छः
Right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice. I personally don't object.
पर्सनली की बात कोई नहीं है।
I'm not objecting to this because I feel that
Okay, it's okay. Chaliye, let's get on with it. Section 6 is okay.
application for fixation of urgent matters, application pleading urgency or seeking interim relief filed in a cause, appeal or matter shall be fixed for it. My objection of this is again that this is a function of the Supreme Court itself, because this relates to the
Please
procedure.
tell us, is it ultra vires a constitution?
It's ultra vires.
Thank you.
I just have a question on you on this, on section 7. Now, section 7 really relates to what is regarded as the nitty-gritty of procedural law. I mean, this is really going, say, in a civil court, into the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question, therefore, is this. The legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point, which I said, that the functions of the Supreme Court have been virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra vires.
Isme Khwaja Sahab,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at one aspect of independence of judiciary, that is freedom from external factors. But there are two other extremely or probably more important factors that affect independence of judiciary, and that is internal independence and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
That will certainly answer your lordship.
Please, one question also.
Since we have just
Raja
one
Sahab.
section, can we just finish reading it?
Raja Sahab, if I may have a supplemental on
Yes,
what
sir.
my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence
Working
of
of
the
the party.
judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers? Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and for the practice and procedure of the court? There is no end to it. Is if at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar. Is this really the solution? That you say, okay, here's a problem internally to the. Would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean, where would that lead us?
With due respect, my
This is a
lord,
question
to
to
my lord, this is
Khaja साहब, ये एक बात सुनिएगा, इधर एक
आप
question.
इसको
Khaja
खत्म तो
साहब,
कर लेना सेक्शन को आप सॉरी टू से
आर्टिकल 8 खत्म कर लो।
आप पढ़ ही नहीं रहे
मैं
हैं।
पढ़ने अभी पढ़ लेता हूँ सर। ये सवाल बड़े पर्टिनेंट
आप हर चीज आप नोट कर लेना।
नोट कर भी दिया मैंने सर। करिएगा ना, मैंने शुरू में ये कहा था।
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें।
मैंने शुरू में ये कहा था, आपने शरीफ साहब और जो ये आप कह रहे हैं कि जो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है उसमें किसी और का दखल नहीं होना चाहिए। ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा।
एक बात और नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the council of his own choice. No, when the law is totally ultra virus, then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or I'm not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, my lord, what I'm saying
Yes,
is that
according to your own
that
arguments.
the question is that you cannot provide a right of appeal,
But you can provide the right of review.
Under 184(3). If 184(3) right of appeal is given in accordance with the constitution, then as far
ख्वाहिद साहब फिर आप अपने लिए आप जो सुन तो लीजिए ना, आप ये सवाल जो है जरा सुन, आप सुन तो लीजिए ना। ये जो सवाल है इनको इतने इजीली ब्रश असाइड ना कीजिए, जरा सुनिए प्लीज। आप गौर और फिक्र से, हम नहीं चाहते हैं कि आप फिलबदी कोई जवाब दे दें जो फिर आपके लिए मुश्किल हो। हम इसीलिए आपको हर सवाल नोट कर लीजिए, आराम से जवाब दे दीजिए। आप खुद अपने लिए मुश्किलात खड़ी कर रहे हैं, हर सवाल पे जवाब देने लगते हैं। हम तो सिर्फ आपसे सवाल पूछिए, नोट कर लीजिएगा आगे चल करके, ठीक है। हम देखें, हम एक दूसरे से बहस करने के लिए नहीं बैठे हैं, हम आपके सुनने का, आपने चैलेंज किया है एक कानून को कि ये गैर आईनी है। ये बहुत फर्क होता है एक कहने के लिए कि मुझे ये कानून पसंद नहीं है। जरा आप प्लीज ना खामोश रहिए 2 मिनट, हम भी आपको सुन लेते हैं खामोशी से, आप भी थोड़ा सा तहम्मुल का इजहार कर लें। तो ये बहुत से कानून है, शायद मुझे भी नहीं ज़ाती तौर पे पसंद हो, ठीक है, मगर मैंने हल्फ उठाया है कि मैं आइन और कानून पे अमल करूंगा, ताकि अनलेस कि मैं उसको स्ट्राइक डाउन कर लूं कानून को, वो एक अलग बात है कि ये अल्ट्रा वायरीज द कॉन्स्टिट्यूशन है। तो आपने कहा माय पर्सनल ओपिनियन डजंट मैटर, तो आपकी भी पर्सनल ओपिनियन की कोई हैसियत नहीं है, आपको आईनी जवाब हर चीज का देना है कि ये इस शिक आपने एक बहस में एक आर्टिकल आइन का आपने रेफर नहीं किया कि ये किस आर्टिकल के तसादुम में है। दूसरी बात आपने जो बिल्कुल नजरअंदाज कर रखी है, ये हमने स्यूमोटो केस नहीं लिया। अगर हमारे हकूक पे इतना जबरदस्त वार पार्लियामेंट ने किया होता तो हमने बहुत सारे केसेस में हमने खुद भी उठा लिए केसेस को। ये तो आप हमारे तरह से वो डिफेंडर के तौर पे रूनुमा हुए हैं और कहा ये जंग मेरी है, ठीक है। ये सिर्फ प्रोसीजर मैटर है, इसमें किसी की राइट गायब नहीं हो रही, किसी की राइट एक राइट कन्फर हो रही है, किसी की राइट छीनी नहीं जा रही है। तो बराए करम आर्टिकल 184(3) के दायरे में रहकर आपने जिसका आपने एक लफ्ज नहीं जिक्र किया है, वो कहता है एनी मैटर ऑफ पब्लिक इंपॉर्टेंस। चलें जी, पब्लिक इंपॉर्टेंस तो एक वो है डिबेटेबल क्वेश्चन, हम ये कहूंगा आप कहेंगे वो है, मगर फॉर द इन्फोर्समेंट ऑफ फंडामेंटल राइट्स, ठीक है, ये इसके प्रीएम्बल में उन्होंने फंडामेंटल राइट्स का तस्करा कर दिया है, जिसको आपने बस नजरअंदाज कर दिया। ठीक है, ये बहुत अच्छी बात है कि आप मेरे हकूक के लिए जंग लड़ रहे हैं, मगर ये मेरे हकूक और आपके हकूक की नहीं बात है, ये आइन की बात है और लोगों के हकूक की बात है। ये आर्टिकल 10(a) का हवाला देता है, आर्टिकल 25 का देता है। तो आप खड़े होकर अपनी राय, आप कॉलम लिखिए अखबार में, हमें सिर्फ और सिर्फ आईनी बहस कीजिए कि ये 184(3) का जो हम जो पावर आज इस्तेमाल कर रहे हैं वो 104, ये हम अपेलेट पावर नहीं इस्तेमाल कर रहे हैं, ना कोई हाई कोर्ट ने कोई फैसला किया है जो हम बैठे हुए हैं एज ऑफ राइट अपील सुन रहे हैं, पिटीशन फॉर लीव टू अपील सुन रहे हैं। हम ओरिजिनल जुरिसडिक्शन में बैठ गए, उसकी बहुत महदूद चीजें, मुझे बहुत सी चीजें कानून में शायद ना पसंद हो, मैं ये नहीं कह सकता हूँ कि जी इसको ऐसा कर लें कि ऐसा नहीं करना चाहिए था। तो आप बराए करम आपने एक इन्फोर्समेंट ऑफ फंडामेंटल राइट से तो आपने कुछ बहस ही नहीं की अभी। जरा आप प्लीज और हर बात को आप नोट कीजिए, अगर आप तो बस आप हर चीज को जवाब देने लगते हैं बगैर सोचिए। हर बात की बहुत अहमियत होती है। मेरे कुलीग की जो सवाल हैं वो बड़े अच्छे सवाल हैं, जरा गौर और फिक्र चाहते हैं और फिर जवाब देते हैं। अगर आप जल्दी से करेंगे फिर आपको दोबारा मौका नहीं देंगे, फिर कहेंगे अब मुझे अच्छा जवाब आ गया। फिर अब आप प्लीज 184(3) के तकाजे भी पूरे कर लें।
आपके बिल्कुल शुक्रिया। 184(3) के तकाजे
मेरा एक सवाल भी नोट कीजिए, केपी ऑन द बॉर्डर प्लीज। आप क्या सोचते हैं एक्ट हैज बीन पास्ड इन द पब्लिक इंटरेस्ट? क्योंकि सेक्शन 5 सबसेक्शन 2 says on the contrary. It appears that to do away with some of the decisions which were passed in the previous years under article 184(3) of the constitution, क्योंकि commencement उनकी कर दी है और उसमें कोई limitation भी नहीं है, तो ये पब्लिक इंटरेस्ट में पास हुए या पर्सनल इंटरेस्ट में हुए?
Yes, your point is noted, sir. I will not answer now. I'll answer later.
Mr. Khwaja, another question.
Sure.
Please एक और note कर लें. We have two provisions in the Constitution. One is Article 191 which relates to Supreme Court, and the other is 202 of the Constitution which relates to High Court. Same अल्फाज है, वहाँ से वहाँ पे Supreme Court, यहाँ पे High Court. Subject to the Constitution and law. लॉ तो बनाती है पार्लियामेंट, तो आपके आर्गुमेंट हम ये समझे कि पार्लियामेंट को आप लॉ मेकिंग में महदूद करना चाहते हैं कि आप ये तो कर सकते हैं, ये नहीं कर सकते, ये रूल्स में सुप्रीम कोर्ट खुद करेगी या हाई कोर्ट खुद करेगी।
मैं इसका आंसर दूंगा, बिल्कुल दूंगा। जब सब्जेक्ट टू कॉन्स्टिट्यूशन आ जाएगा और जो लॉ आएगा वो आपको कॉन्स्टिट्यूशन के साथ देखना पड़ेगा।
ये भी कि क्या लॉ के तहत क्या कर सकते हैं पार्लियामेंट, क्या नहीं कर सकते,
क्या नहीं कर सकती, ये इसका जवाब देंगे जी आपको।
Another question, where a rule has been framed under constitutional power granted to the court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which the review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
through ordinary law or through. The point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the parliament cannot do this thing by an ordinary.
हुजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना।
Anyway, number 7 is application for fixation of urgent matters.
ये तो हो गया।
Application pleading urgency or seeking interim relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ। आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ, मेरी मर्जी। सिर्फ जवाब दे दीजिए, मेरी मर्जी। मैं 10 साल उस केस को नहीं लगाऊं, मेरी मर्जी।
मैंने इसमें कुछ नहीं कहा।
मैं आपसे सवाल पूछ रहा हूँ जी, इन्होंने मेरी मर्जी ले ली, शायद मैं खुश नहीं हूँ उस बात से, मेरी मर्जी में ना लगाऊं केस। एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका, भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें। तो मैं कहूँगा मेरी मर्जी। मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा। इस पे सवाल का जवाब दीजिए, मैं नहीं लगाता हूँ। आपका ये केस आपने फाइल किया, ठीक है, मैं नहीं लगाता इसको। आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं, आपके हाथ पैर कटे हुए हैं। इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की, मैं 2 बातों का इजाफा भी करना चाहता हूँ, और वो है, और वो आइन से पहले भी हमारे पास था, वो हमें ऊपर वाले को हिसाब देना है, ठीक है, अकाउंटेबिलिटी एंड ट्रांसपेरेंसी। आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को, मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीजों को छोड़ करके, ठीक है। इस कानून को उड़ा दे, मैं ताकतवर बन जाता हूँ, ये भी है, मैं अकाउंटेबल हूँ, ये भी एक सवाल है। आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है, ठीक है। और हम सब everyone to exercise powers as a sacred trust. आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे। तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाजा बंद कर रहा हूँ तो वो तो मैं बिल्कुल, मुझे इस्तेमाल नहीं करना चाहिए। तो आप ये पिटिशन लाते हैं, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाती नहीं, तो हम ये बेकेस ही नहीं सुनते कभी। 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे, आप खुश थे उस बात से। तो बराए करम आप ये जो बार बार बात कहते हैं ना, मेरी जाय, मेरी मर्जी, मेरी नहीं है जब मैं चीफ जस्टिस हूँ, तो बराए करम हम वकीलों को बहुत ही कदर करते हैं, मगर मेरा का लफ्ज ना इस्तेमाल कीजिए। अंग्रेजी में कहते हैं मी, माई सेल्फ एंड आई आर द 3 मोस्ट यूजलेस वर्ड्स इन द इंग्लिश लैंग्वेज। इसका मैं उर्दू में तर्जुमा नहीं कर सकता हूँ, शायद आप बेहतर कर सकेंगे। बराए करम आइन का हवाले दे दीजिए किसी चीज के मुतालिक कि ये आइन के तसादुम है, वो आइन से तसादुम रखता है, ये शिक आइन से तसादुम। अभी तक मैंने आपसे वो एक लफ्ज नहीं सुना है इस पे। शुक्रिया।
मैंने तो 3-4 जगह कह दिया है कि जहाँ पे 184(3) में आप अपील का राइट दे रहे हैं थ्रू दिस ऑर्डिनरी लॉ, ये हो नहीं सकता, बिकॉज दिस कैन ओनली बी डन बाय अ कॉन्स्टिट्यूशनल अमेंडमेंट।
लफ्ज लिखा है अग्रीव्ड पर्सन, ठीक है। अब देखिए, अब एक मफहूम तो ये निकलता है 184(3) का कि आप ऐसे मामलों में ना उलझाएं अपने आप को जो इनफरादी नौयत के हों। अग्रीड सर, जरा अग्रीड, आपसे अग्री करें या ना करें, मैं बात कर लूं। इनफरादी नौयत की, अगर हम इनफरादी नौयत के केसेस फैसला करने लगे तो वो बेचारा कहाँ जाएगा। मैं आपको मिसाल दे देता हूँ, रेकोडिक का केस चला, दोनों केस फैसला हो गए तो मैं इस पर बात कर सकता हूँ। रेकोडिक का केस आ गया, ठीक है, सुप्रीम कोर्ट ने 184(3) में एग्रीमेंट उड़ा दिया। मुल्क को, सुप्रीम कोर्ट को नहीं, मुल्क को $6.5 बिलियन की डज लगी। हमने कौन सा जुरिस्डिक्शन इस्तेमाल किया? हमने एडवाइजरी जुरिस्डिक्शन इस्तेमाल किया। अगर हमारे पास ये जुरिस्डिक्शन होता, मैं नहीं कह रहा हूँ फैसले अच्छे थे बुरे थे, मैं सिर्फ उस पर तबसरा कर रहा हूँ, ठीक है। अगर हमारे पास जुरिस्डिक्शन होता, हम वो जुरिस्डिक्शन इस्तेमाल कर लेते। अब हमने एडवाइजरी जुरिस्डिक्शन से मामलों को ठीक सिमत रखने की कोशिश की, ठीक है। आप कहते हैं नहीं, मुल्क को $6.5 बिलियन की डज लग जाए तो लग जाए, आप चीफ जस्टिस की साख पे कमी ना आए। ये ऐसे पावर्स अपने लिए तो नहीं चाहिए। मैं अब वजाहत कर दूं, अगर आप मुझे देना चाहते हैं मैं फिर भी नहीं लेना पसंद फरमाऊंगा। आप प्लीज आइन के तकाजे पूरे करें।
मैं ये मेरा मकसद ही नहीं है। आप मैं ये आंसर कर दूंगा। मैं ये बिल्कुल 184(3) के जो कंडीशंस हैं वो भी मैं आपके सामने पूरी कर दूंगा, और वो 2 कंडीशंस हैं, पब्लिक इंपॉर्टेंस एंड फंडामेंटल राइट्स। फंडामेंटल राइट्स में जी राइटली साइड से
Agar we can go back,
Independence of the
Khwaja Sahab.
judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter, then that full right of appeal is no longer there, it's redundant, it doesn't exist. So what is your, you have read the law now, इसके ऊपर आप बता दें कि what
और
do you have
इसमें
to say
इसी के
about
साथ एक सवाल ख्वाजा साहब इधर हूँ जी जरा 5 मिनट लगते हैं आपको मुझे देखते
नहीं सर
अच्छा,
उसमें
मैं आपसे सिर्फ इसी सवाल का आगे चलते हैं कि इस 4 में लिखा है कि 5 या 5 से ज्यादा जजेस का बेंच बना सकते हैं ना तो फुल कोर्ट भी बना सकते हैं ना 4 में तो फिर 4 को 5 को इकट्ठा पड़े तो अगर फुल कोर्ट बन गया तो फिर उस केस में अपील नहीं होगी बस आप इसका भी जवाब दीजिए
बल्कि इसमें
तो इसमें एड ऑन क्वेश्चन होगा कि डज दैट नॉट मीन कि हम फिर वंस अगेन खुद ही डिसाइड कर लेंगे जहां हम नहीं चाहेंगे कि अपील कोई हो किसी केस का तो फुल बेंच बिठा देंगे does that again not amount to a power being exercised by the court itself? So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
एक क्वेश्चन और भी इसी में ऐड कर लेते हैं इस तरफ ख्वाजा साहब to your right. हम ये भी देखेंगे through this petition there is an order of this court, the act has been suspended. Whether in presence of that order, full court can be constituted or not. ये भी जरा court can be constituted or not.
आप जवाब देना पसंद फरमाएंगे या हम shall we proceed to the next council? फिर आप सोच करके आप जवाब दे दीजिए. ठीक है?
मैंने तो proposition कर दी.
ठीक है. आप आइए. कौन आर्ग्यू करेगा नेक्स्ट? अच्छा. आप अपना किस पिटीशन में जरा बता दें.
तीनों में ख्वाजा साहब के साथ.
जी.
तीनों में ख्वाजा साहब के साथ.
To right of two counsel is not allowed unless you are separate petitioners.
7 में and 6 हम बैठे हैं. एक में आप 7 में मेरी हाजिरी हो गई.
जी चलिए बताइए.
Well, the proposition is the proposition requires to be requested. There is the fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question. With utmost respect, the primary question is whether 184(3) can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction. You have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
Well, Lord, there are a number of judgments.
I'm not interested in judgments. I'm talking about arguments.
I am making submission about it. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court is constitutes.
मैं फिर आपको बात समझाया नहीं सका. For instance, let's take income tax ordinance. ठीक है. ठीक है. उसको आप बिल्कुल स्ट्राइक डाउन कर सकते हैं और उसको चैलेंज भी कर सकते हैं आर्टिकल 199 में हाई कोर्ट के पास. ठीक है. हम क्यों जुरिसडिक्शन एक्सरसाइज करें 184(3) की. ये शायद आपके हिसाब से कानून दुनिया का बदतरीन कानून हो सकता है. ठीक है. मगर बुनियादी सवाल 184 का दरवाजा जब आप खोलेंगे तो उसमें दो चीजें हैं. मैटर ऑफ पब्लिक इंपॉर्टेंस, सीकिंग इन्फोर्समेंट ऑफ फंडामेंटल राइट्स. बता दीजिए कि चलिए पहले वालों को जरा ग्रे एरिया है, दूसरे वाले में तो आप बता सकते हैं ना फंडामेंटल राइट. पार्लियामेंट अच्छा कानून बनाए, बुरा कानून बनाए, ये हम पार्लियामेंट्री डिबेट नहीं करेंगे. आप 184(3) में हो सकता है कल को हाई कोर्ट में आप ये पिटीशन लगाते, वो अलाउ कर देते आपकी पिटीशन, फिर आप हमारे पास एपेलेट जुरिसडिक्शन में आते, हमारे हाथ बहुत खुले होते. अब आपने बहुत नैरो इंतखाब किया है, 184(3) का इंतखाब किया है.
My Lord, there are number of judgments of the Supreme Court.
जजमेंट्स हावी नहीं होते हैं आइन पे. अच्छा, आप 189 पढ़ लें जरा. ये आप लोगों को जरा गलत फहमी क्यों है? 189, एक सेकंड 189 पढ़ लेते हैं साथ में. जरा पढ़िए 189. जी.
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों पर समाअत जारी। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली मर्तबा फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी
क्या है कि आपने इसके ऊपर अवेलेबल फुल कोर्ट किया कि आपके पास 15 जजेस हैं, आपने उन्हें बिठाया है और उसके ऊपर आप फैसला करेंगे, और उस फैसले को इन्हें ये चाहिए कि 2-3 हेयरिंग्स के अंदर करें। सुप्रीम कोर्ट, किसी भी सुप्रीम कोर्ट के अंदर ये नहीं होता कि जी आप 50-50 हेयरिंग्स करें, लंबे लंबे कमेंट्स लें। कॉन्स्टिट्यूशन का पॉइंट
for the whole or any part of Pakistan, and the Presidential Assembly may make laws for the province or any part thereof. 142, subject to the Constitution, Majlis-e-Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your lordship to 191, which is to the effect subject to the Constitution, again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
Which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country under which Federal Court rules of 1950 were made. Under Section 214, subsection 1 of Government of India Act, the Federal Court could make rules but with the prior approval of the Governor General
at that time. And in 1950, the Governor General, of course, was not neither part of Parliament. There was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course, part of some legislative authority as well. Under the 1956 Constitution, Article 177, read with third schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with article, I forget.
What 177?
That said
Subject to law, and then
No, that says subject to law. It says subject to Act of Parliament.
Act of Parliament. But I'll address that, which my Lord has just pointed out.
वो ऐसी तो नहीं है बात है।
I will address, my Lord, that question.
ऐसी बात तो ना करें।
My Lord, as far as, just bear with me.
आपने लिखा भी हुआ है यहाँ पे
Sir,
article
sir, एक second. I'll just Article 177. I'll read it out just for clarity. Until other provisions are made by an Act of Parliament, third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
56 rules were made.
The 56 rules sought rejection of these petitions on the grounds on maintainability for failing to meet the test criteria laid down under Clause 3 of Article 184, which is the matter must be of public importance, first. Second, it must relate to enforcement of fundamental rights. My Lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My Lord, my learned friends, the counsel for the petitioners, they have largely, their case is rooted in lack of legislative competence, not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of Parliament in terms of Article 191. And the argument, my Lord, is that because the powers and because this Honorable Court in 1980 had made rules, therefore, the field stands occupied, and in any event, Parliament could not legislate. My Lord, firstly, in so far as public importance is concerned, my Lord would have now gone through the law, and my Lord would see that this law, in fact, deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD 1990,
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3 was a question that was raised. I'll address it towards the end. And Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, My lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9, as expounded by this court, access to justice and, of course, independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1955, which was the first constitutional order of this country under which federal court rules of 1950 were made. Under section 214, subsection 1 of Government of India Act, the federal court could make rules, but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course, part of some legislative authority as well. Under the 1956 Constitution, Article 177, read with third schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with article, I forget.
What 177?
That said
Subject to law and then...
No, that says subject to law. It says subject to Act of Parliament.
Act of Parliament, but I'll address that, which my Lord has just pointed out. I will address, my Lord, that question. My Lord, as far as... Just bear with me. It's a 1 second. I'll just... Article 177, I'll read it out, just for clarity. Until other provisions are made by an Act of Parliament, third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
56 rules were made.
The 56
rules were made under the 56 Constitution.
56 Constitution, and Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
So as far as...
Is there any difference between Act of Parliament and law?
I'll address that question, my Lord. This is a question that I've noted, I address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make rules with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary, and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you are saying.
No, I'm coming to that.
Keep
I'm
it-
coming
keep
to
it
that.
in mind.
No, I have it in mind. I have it in mind. And when I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action was.
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the president, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
When the constitution, these references, when they say subject to approval of the president, is it unilateral discretion of the president, or it is president advised by the chief executive, albeit the prime minister, whoever that is?
My lord, so if we look at the jurisdictions where we have this position, of course, in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not parliament.
Yes. It was, no, my lord,
But
with
there's a
yes, prior
distinction.
approval.
The prior approval of the president means effectively prior approval of the prime minister, not the legislature.
Yes.
Okay.
You said that in the Indian constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to
There is a
Article 191. I'll come to that. I'll come to that when I take you to
I'm
191.
just clarifying जो आपने argument की.
My lord.
वहाँ ये नहीं लिखा.
जी, when I'll address subject to law, I'll be addressing.
Page 7 you reproduce.
Page 6 and 7, yes, my lord. Now, in other jurisdictions, in United States, for example, this is 28 US Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but is required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
he has to consult.
He has to consult. Now, whether
other than the Lord Chancellor, who is a dying breed sadly in the UK system, but anyway, it's not. Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes. And for that, now I take your lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an act of parliament would be actually covered under the term law or not, or whether we can give it a meaning where an act of parliament would be excluded from the definition of law and everything else would come under the.
Why? I don't even understand this debate. Why is this? What is I couldn't understand the point of counsel. What was he saying really?
My lord, the counsel was arguing, began by referring to clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made. And then clause 2 said that places a limitation, embargo on the state to not make any law which is inconsistent with the provisions of this. With the chapter.
This differentiation between an act of parliament and law, what is the significance here?
My lord,
I missed the point. I tried to.
in my respectful submission, there would be none as far as Article 191
But
is concerned.
you were started by arguing on maintainability. Let's finish your argument. You're now addressing his arguments.
Gee, now what I'm on insofar as maintainability is concerned, my lord, my submissions are that this law actually addresses the public concern. It addresses the issue of public importance by bringing in transparency and by structuring the discretion and by democratizing this institution, by and transparency, by conferring powers, or by, let's say, devolving powers.
So both sides agree that question of public importance is addressed in this. The only question is now whether a fundamental right has been violated, and if a fundamental right has been violated, which fundamental right?
Correct.
Because question of public importance तो आप भी concede कर रहे हैं या कह रहे हैं कि है, इसमें आप उसको मुख्तलिफ तरीके से पॉइंट कर रहे हैं. आप कह रहे हैं जी public importance question है जिसमें हमने address की. The other side doesn't agree, but the common denominator is there is a question of public importance.
I think my lord is correct. To that extent, you are in agreement. Now, the other limb of the argument, I mean, public importance is, in my opinion, a variable. The other importance is enforcement of fundamental rights. And other than that, I think the general, how the law is developed, a law is sustainable unless otherwise proved. So the burden is on the person who challenges a law to say what has been done. If he's invoked Article 199, his jurisdiction is far wider of the high courts. You can attack income tax law, any other law in Pakistan for whatever reason you can, not limited to enforcement of fundamental rights. Attack under 184(3), leaving aside the public importance, and I think you both are probably agreement there, is a narrower attack. So the person has to come within attack on a fundamental right. What is the fundamental right that has been violated? Your arguments, what I could understand from is, rather than violating a fundamental right, this is a beneficial legislation for the litigant, not for me, not for the state. Everyone may benefit by it or none may benefit by it, but there's certainly, you're not taking away anything, that you are stopping a right of appeal, giving a right of appeal. Whether that can be done, that's another argument, constitutional plane. Whether that could be addressed in 184(3) or under 199, it's an argument. I'm seeing myself sitting in original. Otherwise, every case will just be filed in the Supreme Court. Don't bother about the high courts at all. If you read the jurisdiction of 184, can we just read it for my own benefit, because we tend to forget certain words of 184(3). We don't have additional powers, we have lesser powers in the high courts.
Clause 3, my lord.
Pura padhe. One government wala hai na.
Should I read 1 and 2 as well? Yeah, 3 pad do. 3 pad. Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article 199. So the High Court, you don't have to go for a public importance matter. You don't have to go for enforcement of fundamental rights. You can still go to the High Court. Here, we don't have extra powers. We have the same powers as the High Court, but we have two restrictions: public importance and enforcement of fundamental rights. Public importance is variable. Let's stick to fundamental rights. So the power here is not a much larger power. So my reading of the Constitution, a much narrower power than the High Court. High Court may strike down this law, arguably, and then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the bodies of this law.
Just to add to that, where a law deals with powers of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment, where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that position.
But are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed.
आगे बढ़ते हैं.
My lord.
I know you expressed for time.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So
Public importance with reference to the enforcement, with reference to the enforcement.
Here, fundamental, public importance, fine, both parties are there. Now, had it been infringement, then you were right, that there has to be a right which was infringed. Here, it's more wider, it's enforcement. So they are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain, can you expound on that?
My lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well.
General,
my lord.
On my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements है, वो fulfill होती है? Because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So taking
If we'll let you, I think a lot of questions are coming up. We'll note, I'll try to make a point.
These are, my lord, please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going, okay?
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter, a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
Not
be
talking of
affected?
fundamental right, I'm talking of public interest.
Of course.
Of course.
Yeah.
So therefore, if a law,
Again, this is happening, which I must, sorry, interject. I would, with, you have agreed with now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think after चलिए फिर आप note कर लें सवाल.
I just, this part I
Attorney
just
General, if
conclude.
I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but
Yes,
but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने पर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
Yes.
Public interest and this.
जी.
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
But
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now, let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184(3) on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights.
So you say that the word relating to enforcement.
With reference to the enforcement of.
That you say is the buckle that connects the two things.
That is the bundle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined in one night.
Is it not a right that everyone has under the Constitution
My lord,
that laws are
legislative-
made in a particular
The
way?
legislative competence, of course, as I understand it, what you have to see in the act is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the Constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184(3).
So in your opinion, the law is good law, Parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the Constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it. And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is it suspended?
I think my
still
justice colleague has raised a very valid point, and I was thinking about it during the break. If we read the right of appeal, first of all, it talks about an aggrieved person. I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is, we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court, so that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all, it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184(3), the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184(3) can come to their rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed. For instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it on 184(3)? After all, it is a legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words. We are just stuck with these words, 2 words also. Who's harmed by this? The only thing is you've taken away our power, you've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us?
आगे बढ़े थोड़ा सा. If I may stop, sorry, here, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court. And that is, you say you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing because it doesn't, it has to, it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just wondering.
If I may rephrase it before my lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So you may care on this. But breach of legislative competence contrary to the public interest. Until it is related to fundamental right, 184(3) cannot be. Yahi aapki argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your lordship, so before this court under 184(3), these are the two things which are to be examined at the first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. Aage padhne.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. You have your right of appeal been taken away, your right of cross-examination been taken away, have your right of a statement under 340 been taken away.
So that's where then it takes me, my lord, and I just addressing your question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is masters of the roster or five.
I'll go with it, and let me just make my submission on this. I'll go with it. When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
they have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue. But I think we have our own views or opinions. Aap chale aage.
Now
you have to persuade us, not we have to persuade you.
Just one question. I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these. Let's consider what this law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My lord's question is a second appeal would be.
I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? The example I gave you was an extreme example. The first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing?
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो एनलार्ज किया, पहले एक अपील थी, अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
It's noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please, you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be
it does not,
proceeded
yes.
under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, however expansively the term law is defined. My lord, Article 260 has two definitions. One is of an act of parliament and the other is of a federal law. Here we are dealing with a federal law. Article 260 defines a federal law. It says,
you say over here, law includes statute law.
Yes. Yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
If it's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you look at 75.3?
75.3 and 141 and 142 as well. When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura.
So it is what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Awan. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the parliament. The state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any tax.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. You don't say federal law.
It does not. What I'm saying is,
I have a question for you. Suppose a provincial assembly under Article 191 law बना सकती है.
Oh, 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. Because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175 too, for that matter.
Respect, I draw your attention to entry 58.
Relates to the federation also. Yes.
Kindly read it.
Matters which under the constitution are within the legislative competence of parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on parliament to make statute law and in terms of Article 191 is relatable to entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant by the Constitution, by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142, and so on. That's a general. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that entry 51 has no relevance for present issue.
Entry
55 has no relevance. This is a matter between, insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lords may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law. So you can
yes
read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution.
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ फुल कोर्ट की समाअत पीटीवी न्यूज और पीटीवी नेशनल
Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it surely cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Saab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My lord, if I may. Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are
Can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose I compel me. At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases. We are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है. ये 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, फिर हम तनख्वाह नहीं लें स्टेट से. हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये अब इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just
जो आप पढ़ रहे थे
rephrase
constitution of benches का,
जी.
उसको पढ़े ना, ये same as otherwise provided by law.
जी. So
तब तो कोई law था नहीं.
जी, उस वक्त नहीं था. Recognition थी कि law provide कर सकता है कुछ.
नहीं, आपसे ये अभी देखिए,
उस वक्त law
क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे simple, are the 1980 rules law, come within the purview of law?
191 की definition क्या आप
Article 191.
No sir.
No.
These are the rules.
These are the rules. The
But
language says subject to the and the law, the Supreme
But
Court will make rules.
what is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been
Knowing,
promulgated and this covers under this provision.
yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are looking at
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199 and we are trying to